Mention in under compelling circumstances, Malad, may I seek to move a fresh writ petition as an urgent motion, Malad? Malad, this is relating to a railway contract. My client has, Malad, 5 subsisting railway purchase orders, wherein I am to supply certain safety material, elastic railway clips to the railways, to 5 zonal railways. In January 2025, the Railway Board issues a letter, Malad, whereby a process inspection has been modified.
Don't tell me the whole thing.
Yes, Malad.
When is the tender?
Malad, the tender is open. I have delivery schedules which are fixed for these safety items. The Railway Board and the zonal railways implement arbitrarily and unilaterally modifications to my concluded contractual terms, completely setting haywire my entire delivery schedule, Malad. These are safety items, Malad. I will not be able to comply with the delivery schedule under these concluded contracts due to a unilaterally made amendment to my contract, Malad.
No,
After a
but then-
concluded contract, Malad.
No, I don't think there is so much of
Malad,
urgency. You
Malad,
file it in the department.
Ladyship, if I may be permitted to mention, Ladyship, last week, Ladyship had passed an order setting aside the fraud classification order and had told us to mention the other matters. Ladyship, there's 4 other matters. It's a
Which side, original or appellate side?
appellate side, Ladyship.
Give the numbers.
Lordship, under compelling circumstances, I'm mentioning before your Lordship to seek leave. Lordship, these petitioners are shop owners. Now, 2-3 days before these, persons from the municipality, they came, they cross-marked these shops with the intention to demolish it. Without serving any notice, nothing, no procedures were followed. Similar kind of matters are there where these municipality, these Asansol, Durgapur municipality, they had issued the same process for other shop owners. Then this honorable court had intervened and showed dissatisfaction according to their process. Now they're repeating the same process without serving notice, nothing. They have cross-marked, taken photographs, nothing, no notice served, with the intention to just silently demolish my shops. This is my livelihood, your Lordship. I'm seeking leave to file this matter and take this matter urgently.
File it in the department. No leave will be granted.
Lordship, kindly.
No leave will be granted. File.
This matter relates to tender.
Ah.
Second call that was challenged before your Lordship. Your Lordship asked the authority to decide with regard to relaxation of the terms.
Relaxation.
Of the terms and conditions.
Yes.
Because first call, none could be qualified. Second also, none could be qualified. Now, in third call, after your Lordship's order, again, the same tender notice, rather, my Lord, stringent condition.
Yes.
Well, that is under challenge before.
No, nothing doing. File it.
My Lord, item
My
number
Lord, 18th is the day, my Lord, for
File it. Nothing doing. It is their conditions, their terms, whatever they feel like they can do. Yes.
My Lord, item number 1650, my Lord. I mentioned the matter before your Lordship yesterday and your Lordship was pleased to upgrade. My Lord, unfortunately, when I revisited the live streaming of this honorable court, my Lord, I realized that item number 1654 has been upgraded invalidly.
Yes.
Considers my Lord 1650.
Nothing doing.
Your Lordship, may I have your Lordship's kind leave to mention a matter for withdrawal, your Lordship?
Yes, give.
Item 772 of the monthly list, Lordship, it pertains to electricity.
772.
772.
772 released for lack of determination.
Your Lordship, I am mentioning this matter for upgradation. Your Lordship.
No upgradations. Yesterday I have accepted everything.
Your Lordship, my current account is with
Nothing
20
doing.
lakhs.
I'm sorry,
Your Lordship,
cannot
20
help.
lakhs is lying.
Upgradation, my Lord. Yesterday I was not able to get, I was behind, my Lord. I did not get the chance to mention, my Lord. My Lord, item number 883 for the monthly.
Yes, please come next month.
Lordship,
My Lord, kindly, there's my agency, my Lord.
for upgradation, my Lord.
No, don't. No upgradation.
Lordship, it is item number 1333.
Nothing doing.
The
My Lord,
Lordship matter relating to freedom fighter pension. My
Yes,
Lord.
nothing doing.
may I be permitted to mention the
Petitioner is-
matter, my Lord?
yes, it is
My
in
Lord, on
suffering.
27th
Kindly.
February, my Lord, your Lordship, this is the original side matter, your Lordship. Your Lordship, I appear before your Lordship because your Lordship in the civil suit, my Lord. which
What
is
you
pending.
want?
My Lord, I want to tag the matter, my Lord. I have already, your Lordship, directed to mention this matter on Monday, my Lord. But Monday I did not get a chance, my Lord. That's why I'm mentioning to
Tagging. When is the other matter due to appear?
12 March, my Lord.
দেখুন তো কি বলছে?
May I have your Lordship's kind leave to mention, my Lord. This is this NCLT shifting matter, my Lord.
Yes.
I'm appearing for the respondent. Our submission was over, my Lord. The petitioners were
yes,
to give a
yes.
reply for 5 minutes.
Right.
I'm humbly praying for listing this, my Lord, because now we are ready to shift, my Lord.
All right.
And this involves public.
Give notice to the other
I have
side.
given, they are present, my
Oh,
Lord.
you are
Keep
there.
your blessing.
My Lord. On notice,
All
I'm
right.
mentioning, my Lord.
Friday, let it appear.
My Lord.
It is there already in the list.
It is 2164, my Lord.
It
But,
will be upgraded.
my Lord.
Lordship, item,
Yes.
may I be permitted to mention?
Grateful, my Lord.
Item number 1449, Lordship. For the
For what?
monthly list, for upgradation.
No,
Lordship.
nothing doing.
Lordship,
Kindly
there is
help me,
an
urgency,
urgency,
my lord.
Lordship. There is a demolition. There was a demolition order and the
I took up all matters yesterday.
My lord, yesterday we
nothing
got a
doing.
Chance, my lord.
My lord, may I mention one contempt application?
For? No, sorry.
Lordship,
Yes.
may I mention 177 monthly is item number non-prosecution, my lord. 1772.
1772 non-prosecution. Yes.
My lord, order was passed in 18/9/2023, my lord. They are still not complying, my lord. Kindly include this matter. Contempt application.
Were you mentioning something?
Well, may I pray, my lord, before Lordship, my lord, item original said, madam, my lord, 2 to 4 and 6 and 7 may kindly be taken up. But 5 and X, my lord, because a division bench, some matters are there, my lord, immediately will be taken up.
2 to?
2 to 4 and 6 and 7.
2 to 4 and 6 and 7. Keep somebody because you are for the respondents.
I mean, in one case, I am respondent, 6 and 7, I am for the petitioner.
Petitioner. Keep somebody. It will be called on just now.
My lord. Yeah, I am taking your Lordship.
My lord,
Yes, call the list.
My lord, item number 21 of today's list, madam. I am instructed from my client to not to proceed in the matter. I am trying for withdraw, my lord.
Praying for withdrawal when it will be called up, then you mention. Why are you mentioning now?
Lordship,
My lord,
Lordship,
item-
may I be permitted to mention one matter, my lord?
Yes.
Item 78 of monthly list, my lord.
Yes.
Yesterday, I was before the another bench, my lord. I missed the matter and I've heard that it has been made dismissed for default, my lord.
So what can be done?
The order has not been uploaded in the website, my lord.
But the order has been signed. It will be uploaded immediately.
my lord, item number 2166 and item number 2167 of the monthly list, my lord, was mentioned by Mr. Bilodal Bhattacharya yesterday, my lord. Asked Mr. Bhattacharya to mention to a junior, my lord. My lord, I came, my lord, but the list was called, my lord.
Yes,
It
sir.
was heard, my lord, analogously, my lord.
Yes.
But it was mentioned for my lord, upgradation, my lord. May it be upgraded, my lord.
Nothing doing. Item 1. Call the original site.
And for the petition.
here for the respondent number 2.
The writ petition has been dismissed. The details you will find it in the server.
The Union of India. I'm for the Kolkata Municipal Corporation, madam. I'm for the Kolkata Municipal Corporation.
All right. The petitioner is not here. None for the petitioner.
Yes, here for the petition item 4, which is the tagged matter, I mean. Subject to correction.
Item 2. Nobody is there for the petitioner.
I am there, Mr. Shujit Banerjee, madam. They have filed an exception to the report, madam, which I have filed, madam, want to file rejoinder, madam.
You want to file rejoinder?
Rejoinder to the exception, madam.
ওরা ফাইল করেছে?
না আমাকে দিয়েছে কপিটা এখনো ফাইল করেনি madam.
Whose exception?
They have filed report, madam. They have filed exception. They have sub. We want to file.
You want to file rejoinder?
মানে we have not filed any exception to
না,
this.
আমি করিনি, ও ফাইল করেছে।
Why?
Maybe in one matter it has
Yes,
been
yes,
filed.
Sir, Abhishek Mishra, on behalf of Mr.
Whoever. Acha, learned advocate representing the corporation
Yes, madam.
seeks time to file rejoinder to the exception filed by the petitioner. Stop. How soon?
No, you should kindly fix the matter on Friday, my lord. We will affirm and
What is the urgency?
There is no urgency, madam.
already, my lord, interim order has been explained till March, my lord, till the end of March, my lord.
Acha. Let rejoinder be prepared and circulated by 13th of March. List the matter on 25th of March.
20. Madam, all the 3 matters then.
Give your appearances separately because in item 2, nobody is there for the petitioner, none
Yes,
for the
well, we
petitioner.
are
In
for the private respondents.
private respondent is present. Record appearance.
Here.
4 also, it will be the same thing. 4 is same. All right. আমি দেখে নিন ওখানে আগের গুলো সেপারেটলি আপনি একটু দেখে নিন, দেখে নিয়ে করুন। Yes, 5.
Your Lordship, after the order of contempt has been passed, there is a little portion, small portion has been demolished. After that, nothing has been done, Your Lordship. On our last occasion, I have submitted the photographs. The little portion, some portion has been demolished. After that, nothing has been done, Your Lordship.
Yes, let me see. You did not bring photographs today?
Now, my lord, we cannot get a premises vacant. That your lordship would appreciate.
You cannot.
We cannot do it. And the place where the premises is situated is a very sensitive locality. The police even cannot, my lord, we have intimated police that get the building.
Vacated.
Yeah, that also they cannot do.
How big is the building?
We have made all those announcements. Already, my lord, the photographs are there in your lordship, file.
Yes.
Now, my lord, I understand there's an appeal pending also before the tribunal. But there is
No stay order.
Stay or not, I do not.
Had there been stay, it would have been reflected.
Yes.
The moment there is no stay, there is no reflection, only mention of the BT appeal.
Yes.
How big is the construction? How big is the construction?
G+4, your lordship.
And the entire building is unauthorized?
Yes, your lordship.
No sanction?
Nothing has been.
Nothing has been taken?
Your lordship.
And your lordship.
14 by H.
H.
This has to be either a Thika
Thika.
or a Basti. Because with those numbers H and
But
all.
then either Thika or Basti construction requires a sanction.
Yes, yes, your lordship.
Firstly, my lord, construction requires a sanction. Two, my lord, there cannot be any compromise with the unauthorized construction. But I do not want to join any issue so far as that is concerned. Now, my lord, if the police authorities of the state fail, and your lordship appreciates my predicament.
Yes.
My lord, I do not have that force. I can go and demolish. I have
Please
a
come.
demolition squad.
Please come.
And the state is not present. On the other day, I do not think the state was there.
No, this is a contempt, so state is not a party also.
So let.
Who is the other contemptor?
Your lordship.
No, it is only the KMC.
And that also the municipal commissioner.
The peruse the report. Filed by the learned advocate representing the corporation, signed by the assistant engineer and executive engineer within bracket civil, building department, Borough 3, KMC, on 3rd March 2025. Stop. It appears that the four-storied structure, which was constructed unauthorizedly and directed to be demolished, has not been demolished till date.
Because the contents of the third paragraph. So the police was intimated on 9/12/24. Third paragraph.
Yes, yes.
Police was given a notice. In terms of the authority, what I have, 412(2), notice was given to the police to get the premises vacated of the occupants.
আচ্ছা কি বললাম ওটা বলেন তো demolished, directed to be demolished by order of the special officer within bracket special officer on 27th February 2020 has not been implemented till date. Stop. The report mentions that the entire building is fully occupied, and due to continuous stiff resistance from the inmates and the local people, demolition of the building could not be done. Stop. The notice was served upon the Narkaldanga police station, but even the police was not able to get the occupants out of the subject unauthorized structure. Stop paragraph. It appears that an appeal has been preferred before the Municipal Building Tribunal on 24th December 2024. It's a special officer ওখানে ব্র্যাকেটে বিল্ডিং হবে, ঠিক আছে? 2024. Stop. There is no order brought on record showing stay of the order of demolition. Stop paragraph. An unauthorized construction ought not to be permitted to stand for such a long period of time. Stop. As it appears that the officer in charge Narkaldanga police station has failed to get the structure vacated, accordingly, the commissioner of police is directed to render necessary help and assistance to the men and agents of the Kolkata Municipal Corporation at the time of implementation of the order of demolition. Stop. It will be the responsibility of the police to use reasonable force for the purpose of vacating the unauthorized structure. Stop. The matter stands adjourned till it is made clear that in the event the police is unable to get the premises vacated, then the court will be left with no other option but to seek for assistance from the central agencies for the purpose of implementing the order of demolition. Stop. Next. The matter stands adjourned till 6th May 2025 for recording further updates.
Just take the gathering, just note the gathering of
Yes,
the
yes,
people.
I can follow.
When I went
Yes, yes,
for demolition,
I can follow.
and all the buildings in the background,
All same,
all are illegal.
I can understand.
Grateful.
All right, number 6 and 7, both are being heard together. I am appearing for the alleged contempt the respondent. Now, on the earlier occasion, while these contempt applications both were moved by Mr. Alok Ghosh, but he has said that the only issue before your lordship in the contempt is whether the frontage is there or not. 11, no, please wait. 11.8 was what Mr. Ghosh has stated, that 11.8 should have been there. Lordship had recorded that. I said no, the frontage has in fact increased. So lordship directed
Spot inspection.
In the presence of the lawyers. This is my report in the form of affidavit. These are my field notes in my own handwritten. Lordship will only see the last paragraph.
Mr. Ghosh mentioned this matter
this is
in
really
the morning.
unfortunate. Mr. Ghosh was
No, he is engaged.
yes,
He mentioned it
Lordship kindly sees the last paragraph only.
in presence of all. The shutter is opened. The frontage of the shop is measured by the engineers of both sides, and it is 12.5 feet.
Right. More than 11.8. That was my submission.
All right.
Now, after this, nothing remains in the contempt.
All right.
So, this can be disposed of. And my lord, will kindly record their shop room is ready. They can come and take handover
All
any
right.
day and hand over me the temporary shop room. That
Very
once the
well.
content may be dismissed. There is no content on the very first date. I
Very
sent it to
well.
your lordship.
Wait, don't get excited.
But this is not done, my lord.
Affidavit filed by the learned advocate representing the contemnor is taken on record. Stop. The matter stands adjourned till day after tomorrow,
Friday, ma'am.
Friday? Friday 7th. 7th of March.
My lord, we kindly record that this is my specific submission that the
You
shop
have
room is ready.
mentioned it.
No, the shop room is ready. Let them come and take possession.
All right. Very good. Your client wants to take possession or not? Does your client want to take possession?
No, madam.
No?
That is not the frontage of what is my learning saying, ma'am.
All right.
Lordship,
Bring
kindly record.
photographs. Bring photographs.
Yes, ma'am. Yes, ma'am.
আমি জানি না আপনি দেখে নিন যদি সেম থাকে তো আলাদা করবেন যদি উইথ থাকে তাহলে একসাথে করবেন আলাদা আছে
Grateful to your lord.
7 board.
Grateful to your lordship, my lord. My lord, let's keep this on, my lord, Friday.
রেকর্ড ফ্রাইডে
That means on 7th.
রিপোর্ট
7th.
রিপোর্ট রেকর্ডিং দরকার নেই লিস্ট অন ফ্রাইডে
I appear for the petitioner.
I have been requested to appear on behalf of the alleged contempt, my lordship kindly direct him to give me a copy of the application.
I will. It is appearing for the first time. May I just tell your lordship? The point involved is very simple. By an
It's a
order-
contempt matter, isn't it?
Yes, appearing for the first time.
Right.
My lord had been pleased to pass an order directing the concerned executive
Hey,
engineer.
please serve. Please come.
What if they were supposed to give us a hearing and pass an order?
That has not been done.
No order. Hearing has been given on one.
No order has been passed.
No order has been
Very
passed
well.
or communicated. even
Very well,
if
please
it's-
come. The instant writ petition has been filed alleging violation of the direction passed in the order dated 14th September 2023.
Yes. Basically, the
Why did you
respondent-
file the writ petition after a period of contempt after a period of 1 year?
My lord, there are letters. We have been approaching them, my lord, to give us the order. They've just been sitting tight, my lord, and we don't. Maybe the order has been passed, but we have not been given a copy. If my learned friend comes and tells us that the order has been passed or has not been passed, or a copy is given over, the matter can end there. It was regarding unauthorized construction, which my lord is.
All said and done, there is a time period within which a contempt application is required to be
But it's a
filed.
continuous process, my lord. It's a continuous process. The
A
order was-
continuous process is not the explanation in contempt matters.
And my lord, the arbitration was going on also. My lord, let them just come and tell your lordship, my lord, whether the order has been passed or not. We shall be happy with that.
Let a copy of the contempt application be served upon the
Respondent number 4. That's the main person, executive engineer, building department. The concerned executive engineer. Operative portion of your lordship's order is on page 34. Police have stopped the
Somnath
construction.
Boral, is he the executive engineer? He is a special officer, isn't it? Or he is the executive engineer? Respondent number 4. Executive engineer? Acha, tahale 4.
And the
Respondent
hearing
number 4.
Before him.
And an additional copy upon the learned advocate representing the respondent number 4 in court today. Stop. Released on 28th of March.
Grateful man.
Limitation. Nine Manal is to appear on behalf of the Malak petitioner. Now petitioner is an employee of
You are for
Malak
the
Half of the respondents.
which respondent?
1 to 6.
1 to
Committee.
6. All right. Yes, what is
Yes,
the matter?
Malat, is a Malat employee of Malat institution of Malat respondent number 6. That is Malat Imami Fancruz Limited, Malat. The petitioner was subjected to Malat sexual harassment, Malat. A committee was informed after filing of my FIR
Because I have made complaint, immediately I have made complaint to the authority that the person responsible will fix to appoint a committee. So, my lord, after lodging FIR, my lord, after lapse of, my lord, few months, my lord, it has been lodged.
It has been constituted.
Constituted. Now, my lord, I have challenged the constitution of this committee because of 3 or 4, 5 reasons, my lord. One is, my lord, that your lordship will get it from my letter to the respondent number 6. Email, sorry, my lord.
Which page is it?
I'm coming. 1, 2, 3, 4. You want to show me? First one is a confidentiality, because my lord, Act says all the information, my lord, given to the committee should be, my lord, should not be made public. Immediately after lodging my FIR, my complaint to the committee, everything has been disclosed.
To whom?
To my others, my lord, employees, even my lord, my witness, who is going to, my lord, give, my lord, deposition in favor of me, they were threatened.
By whom?
By the others, my lord, employees of the institution, who is, my lord, mastermind is respondent number 6.
All right.
Second thing is that, my lord, there is no rules they have provided how this proceeding should be continued.
Why there is a rule?
Yes, my lord, internal rule is required for, my lord, conducting any, my lord, inquiry as well
Give
as.
me the act once.
Yes. At first, my kindly comes to, my lord, section 4.
Yes. Section 4.
That is the constitution of the, my lord, Internal Complaints Committee.
ICC.
ICC.
Yes.
Every employer of a workplace shall, by an order in writing, constitute a committee to be known as the Internal Complaints Committee, provided that where the offices or authorized units of the workplace are located at different places and divisional or subdivisional level, the internal committee shall be constituted at all administrative units or offices. That is not relevant. Now, my lord, constitution of the committee. That's section 2. Subsection 2, sorry. The internal committee shall consist of the following members to be nominated by the employer, namely 1, a presiding officer who shall be a woman employed at a senior level at a workplace from amongst the employees, provided that in case of a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace referred to in subsection 1. Provided further that in case the other offices and administrative units of the workplace do not have a senior level woman employee, the presiding officer shall be nominated from any other workplace of the same employer or other department or organization. B is not less than 2 members amongst the employees preferably committed to the cause of women. That is a very relevant, my lord. So, my lord, prior experience is required, or who have had experience in social work or have legal knowledge. 1 member from amongst the non-governmental organization or association committed to the cause of women or a person familiar with the issues relating to the sexual harassment, provided that at least 1/2 of the total members so nominated shall be women. So,
How
my lord,
many
that is a
members?
violation of 2.
How many members are there in the committee?
4.
4 are there. How many are women?
Women, that is 2.
2 is there. And the chairperson
There
is
is
a
no,
woman?
they have not disclosed the, my lord, past experience of the, my lord, members.
The chairperson is a member? The woman?
Presiding officer, yes. Presiding
Is
officer.
the
Oh, be ready with the people first.
yes?
So, my lord, I have made a complaint, a series of complaints your lordship will get. Where at first, my lord, kindly turns to page 47. Point wise, madam, I am saying, my lord.
Lack of transparency.
Transparency and RTI on POS policies. The ICC did
What
not
is the
share
RTI you want?
I want money any other committee, my lord. Constitution, every proper committee should be constituted.
What is the impropriety in the committee that is functioning now?
That is, my lord, they have not disclosed the, my lord, past experience of all the members. Because one advocate has been appointed, who is, my lord, respondent number 5 as an external member of the committee. I don't know, my lord, whether, my lord, he has, my lord, she has any personal interest with the company, or she has any, my lord, past experience regarding this.
Personal interest?
Yes, my lord, because, my lord, certainly it affects the, my lord, constitution of the committee as well as the final outcome of the committee. Likewise, my lord, in my lord, your lordship, my lord, in arbitration act, my lord, now the Supreme Court says, my lord, sole arbitrator appointment is illegal. Likewise, my lord, this one,
No,
you cannot appoint any. Let them disclose.
This is not sole.
Let them
There are
disclose
others
the, my lord, past qualification, at least all the members. Now, they are not maintaining, my lord, rules of the, my lord, POS Act. That is, my lord, confidential. They have not maintained, my lord, confidentiality, my lord, of the my complaint.
You've mentioned absence of the presiding officer.
And
Page
one
number
meeting,
47.
my lord, yes, my lord, kindly comes to pad 3. One meeting was till date, my lord. No, my lord, no minutes, my lord, has been provided to the petitioner. The presiding
The
officer.
date of the incident?
Yes.
Date of the incident?
4/6/2024.
4/6/24. Complaint lodged on?
On complaint on 4/6/2024.
Same date.
Same date on 7 and 8. Against 7 and 8. Respondent number 7 and 8.
Against?
Against, yes.
All right, but the complaint was lodged on the same date.
That I have to check it, madam. Kindly give me.
Let me hear once. Respondent numbers 7 and 8.
This is, my lord, your lordship will get, my lord, chronological events from page 29. It seems, my lord, the same day it was lodged.
And this committee was in place prior to the incident taking place, isn't it? Or was it formed after the incident took place?
Yes.
So there is no regular committee. It is only after an incident is reported that the committee is constituted. Right?
That's my information, ma'am.
Your information. Very well. Let me hear.
First thing, there was a committee.
All right.
That committee, lordship, the HR was a member of the committee. The complaint which was lodged by him was lodged by her that could not go before that committee because the HR is a member. So the committee was reconstituted. I mean, placed before your lordship on the 4th of June, she filed a complaint. Lordship will kindly come to page 35.
Yes.
Lordship will kindly see the complaint that she lodged on the 4th of June. Lordship, the first, Lordship will kindly see. First,
no, I'll not go into the merits of the complaint.
So she filed this complaint.
Right.
In this complaint, Lordship, the second, third, fourth complaint was basically that the respondent is trying to usurp her position, is trying to ask her to do illegal activities.
Whatever, that the committee will decide.
The respondent number 6, he called the two parties. They had a meeting, they discussed it, and the matter was resolved as far as the management is concerned. Because the first complaint had no thing to her sexual harassment. Thereafter, she lodged a second complaint in October, 24th of October. When she lost the second complaint on the 24th of October, that is the time that this committee was reconstituted. And your lordship will kindly see who are the members of the committee. The presiding officer, your lordship, she is the company secretary.
She is the company secretary.
Secretary of the company. The second person is
Diksha Singh.
Diksha Singh. Diksha Singh, she is the manager in the company. Then your third person, Chirudeep Roy Chaudhary, he is the chief general manager. Then Advokanti Saha is a general manager. And the fifth person is a lady advocate of this Honorable High Court. So this is the committee, your lordship. Now he says that the antecedents of these members should be given to. Lordship, what is he asking?
And it's known to him.
It is known to him who are these members. And she herself, your lordship, is a senior executive HR of the company. It's not that she's a junior member or she's a lay employee. She's an HR. She knows these people. And yet, your lordship, she's just dragging this company. Lordship, on the first day of the meeting, when the meeting was called, that day, unfortunately, the presiding officer suddenly fell sick. She was supposed to join on video. Virtual mode. The virtual mode for technical glitch did not happen. So the first day, there was no meeting at all. No meeting was held.
But then why don't the committee consider it and dispose it off immediately? It's pending. He says the hearings are not taking place.
After that, your lordship, meetings are being held. The presiding officer personally met her, tried to help her out. Then, your lordship, she made a complaint to the respondent number 6, saying that the respondent, who is before your lordship at 7 and 8, that the respondents are still harassing her. He informed the committee. The committee recommended that the respondent number 6 be asked to go on leave, and respondent number 7 is a vendor. So he should be stopped from coming to the premises. Steps have been taken on the basis of the recommendation of the committee to stay the respondent number 6, who's 7, who is the respondent in the complaint. Steps have been taken to ask him to go on leave. The respondent number 8, his contract has been discontinued because he is one of the main respondents in her complaint. Lordship, the committee, she appeared before the committee on the last occasion, your lordship. That was on the 19th of January.
9th of February, I
19th
raised
February.
objection regarding.
She has given documents on that date before the committee. And thereafter, she has filed this writ petition.
I have raised objection
And she
regarding
filed
the
it on the 1st.
constitution of
She appeared before the ICC committee on the 19th. She said that I have objections, but I will cooperate. I may cooperate. And then she has filed the writ petition. Lordship, everything is being done. There is nothing. The committee has gone out of their way, though she is not appearing before the committee. On the basis of her complaints made and forwarded to the committee has recommended the employer. And Lordship, a company secretary, he has knowledge of what is happening. Lordship, the entire
Knowledge of what is happening in the company is something else.
Of an internal committee. The internal committee, Lordship, does not envisage that outsiders having prior experience in these sort of matters will be brought in. The entire constitution of the internal committee, Lordship. The presiding officer will be a lady employee, senior lady employee. It does not say that she has to have experience.
No, little bit of experience is required because this is what the Act says. That this is what the Act says.
2 subsection B, my lord. Kindly.
Yes.
Being a senior in the organization.
Holding any post, my lord.
Is the seniority. Because, Your Lordship, if there is going to be an internal committee, then every institution will require to employ senior lady employees who have got experience in these sort of matters.
It has to be because this is what the Act contemplates.
Yeah, Lordship will kindly read that.
Yes.
Yes. Secretary.
Lordship will
And is there anybody from the NGO?
Lordship, the fourth person, the fifth is, she's a member of the of this Honorable High Court. She's a lady advocate. And she has enough experience.
One member from the NGO or associations committed to the cause of women.
person familiar with the issues relating to sexual harassment.
Right.
Lordship, there are the person, the fifth member is a lady advocate of this Honorable High Court, and she has got experience. She's a member also in other.
Lady advocate, but then is she aware of these provisions of the Sexual Harassment Act?
A member in other ICCs also.
Other ICCs also. All right.
At first, my lord, is the sub B, my lord, B.
Lordship will kindly see the constitution of the internal committee.
Yes.
The internal committee shall consist of the following members to be nominated by the employer. A presiding officer who shall be a woman employed at a senior level at workplace from amongst the employees. So, Lordship, here we have got a company. A company secretary, Lordship, the entire course takes her through the entire rules related to sexual harassment. They have posh awareness programs in the company. They go for these awareness programs. They are trained to go to these awareness programs. Then your Lordship will kindly come B. Not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. Legal knowledge. Lordship, here she's a manager and the chief general manager. Lordship, they have legal knowledge. They have also attended number of posh awakening and sensitization programs. They have that. Lordship, the entire concept of sexual harassment at workplace is to have representations from the workplace and one outside.
No, but then how the allegation is that you go and disclose everything what is there in the complaint to others and everybody. Lack of confidentiality.
Lordship will kindly
Lack of transparency also.
Lordship will kindly see it has been given to him, the constitution of the committee and the designation of each member has been provided to him.
No, and the persons in the committee go and disclose everything to the other members of the institution.
Lordship, no.
That's
no,
not correct.
That is not correct. Lordship,
the witnesses are being threatened.
Lordship, that is not correct. Because your Lordship, if witnesses had been threatened, who is threatening the witnesses? She makes a complaint to the employer that the respondent, the private respondent, the respondents accused are threatening me. They have been asked to leave, go on leave. Lordship, who is threatening her? Lordship, she is a senior HR. Lordship, on the last day when she appears before the ICC the first time, she comes with her witness.
And witnesses from the company itself?
Yes, your Lordship. Her witnesses all employees of the company. So, Lordship, who is talking and who is not talking, your Lordship, in the company? How can it be relegated to information gained from the committee?
Paragraph 17.
When is the next date? When is the next date?
It is first March, I think.
1st March, it was 1st March.
1st of March.
Adjournment on that date stating that I have filed my lord petition. I've already mailed them. My lord, kindly says, my lord.
Let the sittings of the committee be held. And
I am appearing for the managing director, my lord. May I just draw your, because our stand is that we want to remain neutral. We don't want to, my lord, there should not be any difficulty. We'll abide by anything, my lord, which falls from your lordship. But I want your lordship to, my lord, please see the substance of the, my lord, aspersions against the committee in paragraph 17. Then if your lordship feels we should do something, we'll immediately do it. Lord, please come to paragraph 17 once.
Page?
Lord, page 13. Lord, 17A, my lord, is absence of presiding officer on 30th October. But what, my lord, my learned senior friend had mentioned. Nothing happened on that date. 2 is compromised external member. You know, there's no basis for this. Learned advocate was, my lord, appointed for technical knowledge. C, my lord, there's nothing shown. C is, my lord, breach of confidentiality. Sensitive information and evidence and details about witnesses shared by the petitioner in the ICC meeting was disclosed to the accused, leading to serious threats to witnesses named in the hearing on 30th October 2024. My learned friend has already explained This is completely, my lord, without basis. Then questionable and untrustworthy ICC posh procedure. No guidelines followed. Lord, there's no basis for saying this. Lack of right to information on posh policies. Now, my lord, this is the petition before your lordship. Your lordship has heard the matter. I am the managing director. Your lordship, my lord, tells me to do whatever your lordship feels, my lord, we'll do that. We don't want to take sides. We don't want to compromise a statutory inquiry, hearing. Whatever your lordship feels, we'll do. We have no difficulty. And these are my specific instructions.
And did you lodge any complaint before the police?
Yes, yes.
Police complaint is also there.
Lodge complaint,
Uh,
we
fair.
have appeared, surrendered and obtained bail.
Obtained bail. All right. You participate in the proceedings?
May I response to this, my lord? May I respond to this?
Yes.
First, my lord, the same paragraph I am reading, my lord, it starts from 13, paragraph 17.
No, don't read. He has already read it.
Yes.
Thing is, you participate in the meeting and see what happens. The matter will be kept pending. Please come. First was the date. It has been extended. The date has been adjourned.
No, no, no.
On your request.
No, it has started from 30th October.
No, 1st of March.
No, that's the last date here.
Yes, it has been adjourned, isn't it? When is the next date?
I don't know, my lord.
You don't know. And the copies of the meetings, the resolution of the meetings are not forwarded to you. Acha, theek ache. The petitioner has raised allegation with regard to the constitution of the Internal Complaints Committee under the sexual harassment of women at workplace, bracket open, prevention, prohibition and redressal, bracket close, Act, 2013. Stop. A complaint was lodged by the petitioner before the committee on 4th of June 2024. Stop. The petitioner alleges that the committee is not functioning in accordance with the provisions of the Act. Stop. Several allegations have been raised against the committee. Stop. Paragraph. The last date of the meeting of the ICC was on 1st March 2025, which stood adjourned on the request of the petitioner. Stop. Paragraph. The committee is directed to take steps strictly in accordance with the provisions of the Act. Stop. The resolutions of the day-to-day meeting held by the committee shall be forwarded to the petitioner. Stop. The petitioner is directed to cooperate with the functioning of the committee. Stop. The matter is adjourned till 8th of April 2025. Stop. The report of the committee shall be placed before this court on the adjourned date.
My lord, may I prefer only one thing, my lord? The entire meeting should be done through my lord CCTV, my lord. Kindly make it clear, my lord.
CCTV?
Yes, my lord. Because so it can be produced before your lordship, my lord.
You want
Before.
video recordings to be
Video,
done?
yes. Video recording.
And then who is going to manage these videos? How do you know whether the confidentiality of the videos will be
Only that
questioned?
should be placed before your lordship, not to any other person, my lord, only to your lordship.
You never know where it will go by the time it comes to the court. Why you will keep all these things? I do not think there is any requirement. Are you permitted to take the help of a legal representative?
No, she has not taken. My lord,
Does she choose to take one?
I have to take instruction. I
Lordship,
don't.
on the last occasion when she appeared, the only time she has appeared with one person, Mr. Anand Shekhar.
Is he a legal representative? Co-employee. It's permissible.
And the committee has not.
Not stopped. Very well. It's all right.
She's got a poem.
Let us see what happens.
My lord is fixing the next date on
8th of April.
I am for the petitioner, my lord.
If that be so, the special officer, 1 minute. The special officer is not an employee of the corporation. So getting a report from him will be difficult. Who is the executive engineer? যেখানে বলেছিলাম সোমনাথ বড়াল, ওখানে আপনি লিখুন, আচ্ছা, let it be served. ওটা থাকুক, আপনি আর একটা সেন্টেন্স অ্যাড আপ করুন। The executive engineer is directed to file a report before this court on the urgent date. You get a report from the executive engineer because the special officer is not going to report to you. No, I just recollected that he is the... Very well.
Your ladyship, I am
appearing on behalf of the respondent 2, which is the stress assessment.
My lord,
management
kindly see the
branch.
last order, my lord. Last two paragraphs, your lordship, I was the grantor of the corporation.
Ladyship, on the last occasion, you had come.
Let my read. Nothing filed till yet.
Yes. What is it?
Your ladyship, you have asked us to come up with written instructions on
Yes.
two questions. Firstly, whether they have been given an opportunity to be heard before being declared fraud. And secondly, whether we acted in consonance with the decision of the High Court of 1910-2023, whereby they were asked to give an opportunity.
Give a copy to him also.
Risha, I
For-
will provide a copy. I have
Yes.
shared the contents. Regarding the...
Go through it and come back.
This is nothing, my lord, this simple thing, my lord. I can just, I've seen it from my land.
You've seen it?
Yes,
What is it?
Just seen it, my
Your
lord.
ladyship, in the first issue, whether they were given an opportunity to be heard before being declared fraud, the fraud was declared on 2/3/2022, your lordship. At that time, the RBI master direction of
Did
the
not
year
require.
2016 was applicable and it was not required to give an opportunity to be heard. After subsequent to that, the judgment of SBI versus Rajesh Agarwal came in 2023. The RBI revised their master directions, and in the 2024 direction, they say that we have to provide an opportunity to be heard. So we are revisiting their declaration of fraud, and we have provided 21 days notice for them to appear in front of us in consonance with the principles of natural justice.
Let
Well,
me see the
next
writ
point.
petition.
I respond, my lord. My lord, this is
Yes.
the judgment of the Honorable Supreme Court. Where Honorable Supreme Court, my, this is that judgment. Particularly, my lord, this judgment they are referring, page 63, my lord, that is the entry notice. Page 63, my lord. At the last page, my lord, conclusion page, my lord.
Yes.
Here, my lord, first thing, my lord, law is settled that the judgment always have a retrospective effect.
They will give you an opportunity of hearing.
No, my lord, they have already declared me. My lord, here, my Supreme Court is saying that.
They are going to revisit the issue. This is what the submission is.
No, but they are, my lord, saying that why it should not be continued as fraud, my lord. They're asking me that why you have been declared fraud secretly. No, you, in terms of the Supreme Court judgment, which they are wrongly interpreting, my lord, Supreme Court is saying the application of odi alteram partem cannot be impliedly excluded from the master directions of
Yes,
fraud.
yes, I have followed.
So, but that thing, it cannot be impliedly. They're saying it is impliedly excluded. So, your lordship, they have impliedly excluded as page 63, my lord, last paragraph they are saying. Point 5 of that judgment, my lord, point 5 of last page, point 5, my lord. So subsequently, my lord, even Bombay High Court has, my lord, this had directed all the banks to recall all notices, my lord, whosoever it is issued, my lord. It is not a legislation, it is a judgment. Legislation may have a prospective effect, but judgment always have a retrospective effect, your lordship. So, my lord, second thing, your lordship, was there, which my learned friend is saying that what action they have taken upon that in terms of that particular order of the Honorable High Court. My lord, they have stating that they have not received any reply because I have submitted the reply before this, my lord, willful defaulter identification committee at Bombay. So they have not actually any information of that. This is a lack of coordination between the same bank. So we can say that, my lord. Now. And my lord, very interesting point, my lord, they have supported my case also, your lordship. My lord, page 2, paragraph A of their instructions.
Is this regarding fraud or willful default? Which one?
It's regarding fraud, and there are two distinct procedures against. And
Yes, so it is a fraud, declaration of fraud, right? So you are required to give an opportunity of hearing, which you just now mentioned that the entire issue will be revisited. But your show cause notice mentions that why it should not be continued as fraud. So that means you hold him guilty prior to him giving a chance to revert with his instructions.
He was declared fraud in 2023. The same was communicated to RBI. The master directions were not present at that time. So after the directions have came, we are reopening the case. We are giving
Very
an
well.
opportunity to represent, and if he can show that.
Please come.
Your leadership regarding
Actually, my last
second question,
which your lordship, he's saying that my lord, he might be saying I've suppressed something, my lord, which is
The
annexed to
report
the
has been filed by the Assistant General Manager, Central Bank of India, Sam Branch, Kolkata. Dated 1st March 2025. Stop. The Learned Counsel representing the bank submits that the bank will revisit the issue in terms of the direction passed by the Honorable Supreme Court in the matter of State Bank of India versus Rajesh Agarwal, reported in AIR Online 2023 SC 256. Stop paragraph. As the bank intends to revisit the issue in the light of the observations made in the matter of Rajesh Agarwal within brackets Supra, accordingly, the show cause notice issued by the bank requiring the petitioner to submit his representation, submit his show cause. Why he should not be continued as fraud is liable to be set aside. Stop. The bank cannot declare the petitioner as a fraud prior to giving him the opportunity of hearing as mandated by the Honorable Supreme Court. Stop paragraph. Next. In view of the above, it will be open for the bank to seek response from the petitioner. Stop. The petitioner will be obliged to respond to the notice given by the bank. Stop. The bank shall thereafter take steps in accordance with law. Stop. The writ petition stands disposed of.
The second paragraph, my lord, of second issue, they have not decided, my lord. Second issue, which your lordship in the second last paragraph stated that, my lord, last order.
It's concerning the willful defaulter.
It is concerning willful defaulter, my lord. That High Court order has not been complied with, your lordship, particularly in the second last paragraph of your lordship.
Yes. Any response made to the willful defaulter committee?
So they were asked to give a submission before the willful defaulter committee.
Did he give?
So
yes,
till
my lord.
date, they have communicated with the stressed asset management branch of CBI. So if your leadership comes to page
53, my lord.
Tell me whether any response was there. Did the willful
correct address, your leadership? They
No,
have
kindly
sent
see 53.
Central Bank of India some willful defaulter committee. in
Yes, sir,
Mumbai.
willful.
They have not CC'd us. They have not informed us that they have sent anything. These addresses, we did not provide them this address.
Where is the response?
Well,
Where
page
is-
53, my lord, page 53, your lordship, kindly see, my This is the actual authority, willful defaulter identification committee and review committee of the willful default. Both these
Ladyship,
committees.
these addresses are incorrect. They have come up with these addresses and sent them. We did not provide them.
Okay, as regards the declaration of the petitioner as willful defaulter, comma, the petitioner appears to have forwarded his representation to an address which the bank, which the learned counsel for the bank submits as incorrect. Stop paragraph. Which is the correct address?
Stressed asset management. They have communicated with us in the previous occasion. Stressed asset management branch.
You have the right now. It is there in page 53.
Yeah,
You take steps.
Your ladyship, it's present in the instructions I have submitted. The correct address is present. Stressed asset management branch of.
But then you have the response. Why doesn't the willful defaulter committee go into this? Right?
Yeah.
The response of the petitioner is annexed to the writ petition. Stop. The willful defaulter identification committee shall consider the same in accordance with law.
Highly grateful.
Disposed.
Your ladyship, they can issue the same to us in our correct address.
It will be open for the petitioner to forward a copy of the representation regarding willful default to the respondent authorities at the correct address. Where is it? SAM branch, where is the address? Second floor, 33 NS Road.
Respondent number 2, my.
At the second floor, 33 NS Road, Kolkata, 700001.
Highly grateful, my. Grateful.
Lordship,
Petitioner?
petition. Lordship, kindly come to page number 85. It is the third occasion, Lordship. This matter is coming before your Lordship. On the last two occasions, Lordship, order been passed. So at page number 85, this honorable bench have already passed this order. Thereafter, Lordship, kindly come to page number 85, Lordship.
Yes, 85.
85. A specific order was passed. During the pendency of this earlier petition, they have refunded the overcharged prevent charges. Thereafter, Lordship, specific order was passed and the reply is at page number 91 started and the effective page is at page number 95. 95, middle portion. To contention, Lordship, overcharged been refunded, but the interest for the 1 month for withholding was not paid. So it is the 95.
Tell me one thing, you were directed to take instruction. Why on the advocate's letterhead the reply has come? Isn't it?
Yes, Lord.
I believe, my lord, I may have understood wrong. But I was under the impression whether a reply has been given to him or not had fallen from you.
No reply has been given. It should be given by the bank. Why through the learned advocate? The bank is the party. Why the learned advocate will, and see, in the body of the letter also, there is no mention that he is representing the bank.
Yes, at page
My
number,
client, what is usually given, first page body as to who the person is.
representing.
Nothing.
On whose instruction this reply is given, nothing is there. And Lordship, this learned advocate
However,
was not present.
I have specifically taken instruction. The bank relies on this letter and does not disown it. Your lordship can record that bank is not disowning this letter.
Yes.
Lordship, at page number 95, middle
Yes.
portion, they have admitted that with the overcharging principle outlined by the Reserve Bank of India. So they have admitted that the deduction was overcharged on their part and they have rightly refunded the same to my client. Now they are bank, Lordship, they are in default in paying the interest for the withholding period of 1 year, that for that period they have withheld the amount. And upon filing of this writ petition, after a 1 year of that deduction, they have refunded. So my contention is, Lordship, they are bank. When the
You want interest on account of the money which they held unauthorized
for the delay.
for the delay.
Yes, for the withholding, because I am a business person, I have taken loan from other bank. So this is the loan part. So I have to pay that portion. And the second prayer is, Lordship, that as per RBI guideline and notification, they are also admitting that within a period of 30 days from the prepayment, they must refund the security, collateral securities. And in this letter, they have admitted they have made a delay of 45 days. So on that part, Lordship, RBI guideline is for each day, they have to pay penal interest of 5,000 rupees per day of that delay portion.
What is the collateral security that was deposited? Bank, the
title deeds and the factory
documents relating to the factory.
And Lordship, I want to show, Lordship, at page number 92, bottom, paragraph 2. The takeover by PNB in August 2023. So in this letter, page number 92, bottom.
92 is the letter of the learned advocate.
Yes, by their letter, so that there must not be any issue. I want to show from their letter they are admitting.
Yes.
That in page August 2023, from PNB, the loan was takeover. That is, prepayment is made, everything done. Now kindly come to page number 93, middle portion, page 5, para 5. They are admitting the demand. No, Lordship, sorry. Page number 94. 94, middle portion. Kindly come. NOC was issued on 18/10/2023 and digital signature was uploaded on 13/12/2023. Digital signature means, Lordship, we are registered concern of ROC. When they issue a paper, that is NOC certificate, they must confirm it by putting digital signature uploaded to the ROC site. So only after this, other bank will rely that my collateral security is free. So the entire process, I have made a table. The entire process is made for 46 day delay, and I have prepared a table which is at page number 100. So
all
it is
right.
a calculation.
What is the response of the bank?
I just want.
With regard to delay, my lord, may I say this, that during the first round of litigation, your lordship had directed us to call him for a meeting and consider this issue. We called him, discussed this, minutized this, and after this, we released everything. And there were several formalities for issuance of NOC, issuance of return of title deeds, there were bank guarantees, we had to adjust the bank guarantees. Everything was done in phase-wise manner. For the delay, I have to use an affidavit why this delay happened and what were the stages, whether he is at all responsible for the delay or for compliances, or we are entirely responsible on my lord, oral submission probably. This
Lordship, may I submit here? Lordship, kindly come to page number 99 where the notification is quoted. So in this notification, there is
I am not in dispute that
the notification is there, they are bound by it.
They are bound, but there is specific.
Whether his contention is whether the delay was attributable to you or not. Nothing more than that.
So
were you responsible for the delay?
So the responsibility goes to directly to the bank because as per the notification. Because I am paying for them to once, Lordship, I have paid the money. Then what should be the reason behind it that I will put the X on my own leg? Lordship, this is a tactic to further proceed because bank is highly financially equitable because for this 1 year, my client have to pay lot of fees to me and every time they went to.
You could have done pro bono matters.
No, not sir.
Why not? You could have saved the client of further expenditure. Achha. The petitioner prays for interest on account of the delay in releasing the original mortgage deed
phone number
and also praise for interest on the
office floor
delay in refunding the final payment. No, what exactly do you want? The deeds and what else?
Deeds were his, amounts, NOCs were given. He had now taken a change to PNB.
So it is the delay in only releasing the papers.
Papers and the
collateral security.
And the collateral security. And the other collateral securities deposited by the petitioner at the time of obtaining the loan. Stop paragraph. Learned advocate representing the bank seeks time to file an affidavit explaining the delay. Stop. Let such affidavit be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing.
And your lordship, to only indicate that my submission is, we do not admit that it was attributable to us, the delay.
It has been submitted that the delay caused was not attributable to the bank.
Lordship, Lordship kindly record they have admitted they will refund the interest portion. Interest they have not.
Where they have admitted in the letter?
No. Yes.
Letter is already on record. What is there to further record?
Disputing that they will refund the interest. They will put affidavit only in part of they are attributed to my part of delay on their part.
Whatever is there in the letter is there. Next.
Indian.
Na hearing, Doctor.
Lordship, item number 12, I will be seeking 3 weeks time to comply your Lordship direction. There is a dispute with regard to 4,91,000 with my erstwhile banker. I am a transferee bank. Had deducted against payment charges for a loan which has been transferred.
Yes.
So since the records are not being located because the transfer to the branch has also shifted, we are not in a position to file an affidavit.
So for purpose of filing affidavit?
Yeah, 3 weeks. So that we can make it clear whether...
My lord, RBI would also like to use an affidavit in the matter. Already
Why
the
did you not
direction...
use it?
My lord, initially we thought that will not come on affidavit, but I have found out a communication from the bank,
advocate
which needs to be
representing the banks.
only for the limited purpose
Respondent
of that.
banks seeks extension of time for filing the affidavit in opposition. Paragraph on such prayer, comma. Time to file the affidavit in opposition is extended till 28th of March. 28. Stop. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing.
Grateful, Lordship.
Deep
আমি দিয়ে দিয়েছি।
I hope I've be able to be of some assistance to my lord. This is in the implementation of sugar control order. It appears that when we checked up, there is sugar control order also, like Jute. Under sugar control order, the Directorate of Sugar is empowered to call for information, also search and seizure, which the Jute Commissioner is empowered under Section 8. Also ask for information, and also the Jute Commissioner is empowered under the Jute Textile Control Order. Now, it appears that the Sugar Commissioner, that Sugar Directorate had issued particulars had issued notice to the sugar mills, asking for particulars. Kindly take the report. Kindly take the report which has been filed on 25th February. They have annexed at page 36 in their report. On 19th December 2024.
To CEOs and MDs of all sugar mills.
Yes. So they have all the details.
Yes.
And Lordship, see paragraph 3, paragraph 2. All the sugar mills are hereby again directed to place their orders for procurement of jute bags for packing 20% of sugar produced in 24-25 and ensure compliance with Ministry of Textile orders so and so. All sugar mills are directed to provide the details of procurement of jute bags and quantity of sugar quantity in sugar season so and so. Non-compliance of the directions issued by the Directorate of Jute Packaging of 20% of sugar produced during the current sugar season will be viewed seriously, and strict action will be taken against non-compliant sugar mills under the provisions of the Sugar Control Order and Section 3. Now, apropos this, Lordship kindly comes to page 3, paragraph 10. They must have collected information they also collect regularly. Paragraph 10, they have summarized to what extent this control order, these compulsory packaging notifications are being implemented. Without any manner admitting it, well, I can't really check, but then there's an admission here at least, paragraph 10. According to us, it is much more violation. It is submitted that despite these challenges, sugar mills managed to package about 45 LMT of sugar, 14% of sugar produced in sugar 23-24 in jute bags. What is alarming is in sugar season 24-25, 5.64 lakhs of sugar packed in about 1.13 crore bags as on 31st of January 2025. And this is, and the maximum packaging happens between till April, March to April. So there's a dismal compliance with the notification. Now, under the textile control order, there is power of search and seizure also. That Lordship will find, I'm sorry, sugar control order. Yes, may I hand up a copy of that order to my lord and give it to the other side also? Lordship sees Rule 11, equivalent to our textile control order rule, I think 8, and also section 8 of the Jute Packaging Act. Rule 11, inspection, entry, search and seizure. I am more particularly on G. Seizure of sugar because they are not being packed. Now, we have proposed a suggested, a small suggestion, of course, for my lord to consider. In this line, I have shown to Mr. Jointo Mitra also. I should kindly consider this proposal, which will be workable possibly because Jute Commission is saying that they are sitting in Calcutta. It is not possible to consider violation. Now, first paragraph, I have said that they have collected all the details. Now, see paragraphs 2, 3 and 4. 2, 3 and 4 is what I propose, is what, if your lordship may consider. Accordingly, the Directorate of Sugar should exercise its powers under Rule 11. So they are also notified under the Jute Packaging Act to implement the provisions. 11 for seizure of requisite quantity of sugar so as to ensure packaging thereof. That seizure can be also by the Jute Commission exercise the powers under 8.2 of the Jute Packaging Act. Now, as per Ministry of Textile notification, both Jute Commission and its deputy as well as Director of Sugar are empowered to exercise powers under Section 8. Since the respondent numbers 5 and 6 obtain full details from the sugar mills regarding packaging of sugar in jute bags, the respondent number 5 should file necessary complaints under Section 9 within 4 weeks from the date of the said order for imposition of fine on non-compliant sugar mills, because they have all the details. Particulars of all such complaints and steps taken should be regularly submitted to respondent by respondent number 5 to respondent 2 and 3. Jute Commissioner is, after all, the guardian of the jute industry. He should be updated, and if he gets it, we will also get those particulars. And the petitioner to ensure that the order of court is complied with. And now paragraph 5 is regarding food grains, which I can come back later. But up 3 and 4, I was humbly submitting. Paragraphs 2, 3 and 4, Lordship may consider. Otherwise, there is no way that this can be done. And also, the season is getting over. We've got really 2 months of packaging left.
Yes.
My lord, as far as respondent number 5 and 6 is concerned, I will take few minutes, your lordship, and I am going to establish, your lordship, that my learned friend is trying to distort the fact, and relevant facts has not been put before your lordship. So, your lordship, my suggestion, that is para number 1, Ministry of Textile issued gazette order on dated 31st March 2000.
Where are you reading from?
From suggestion, your lordship, that I have submitted on last
That report,
your
Report,
lordship,
yes.
on behalf of respondent number 5 and
Right.
6. That
Which
is
paragraph?
that is paragraph number 1, your lordship. Ministry of Textile issued gazette order dated 31st March 2023 under the provision of Jute Packaging Material Act, JPM Act 1987. And as per order, 20% of the total production of sugar is to be mandatorily packed in the jute packaging material. And second para is, your lordship, that immediately all sugar mills were directed, white letter 24th April 2023, for strict compliance of gazette order dated 31st March 2023. That is annexure number 1, your lordship. And that is by Ministry of Consumer Affairs, Food and Public Distribution. And your lordship, just to resolve this issue, there are several stakeholders, your lordship, and that's necessary to aware with all the facts and circumstances of this case, your lordship. And that is para number 4. The Sugar Industry Association as well as sugar mills submitted various representations highlighting the following challenges for jute packaging. First one is sugar has inherent properties that make it susceptible to moisture absorption. Jute bags have a higher tendency to attract and retain moisture, which poses a significant risk to quality and integrity of sugar stored. Within these bags, moisture can lead to the clumping and caking of sugar, rendering it unfit for human consumption. And second one is non-acceptance of sugar packed in jute bags by the bulk consumers. That is the most glaring fact of this case, your lordship, that bulk consumers like Pepsi, Coke, etc., due to mixture of jute fibers in the sugar packed inside the jute bags. And your lordship, third point is jute bags are costlier than SDP/PP open bags, which would result in additional cost to the sugar mills. And fourth one is the bulk storage requirement of sugar mills differ significantly from those of grains like wheat and rice, for which jute bags are better suited, your lordship. And lordship, that para number 5, considering the above representation, the Standing Advisory Committee, Ministry of Textile, was represented by letter 18th September 2023 and again on 3rd December 2024 to exempt sugar from the mandatory jute packaging. But that, your lordship, it is also a fact that sugar has not been exempted and from mandatory jute packaging under Section 5 of Sugar Control Order 1966. All the sugar mills were directed by letters. There are a number of letters written, your lordship, to the sugar industry for meticulous compliance of mandatory use of 20% jute bags in the packaging of sugar. And your lordship, the fact is about 70% of total sugar produced in sugar season is consumed by bulk consumers, processors, sector, who had shown their reluctance in just procuring sugar packed in jute bags. So due to quality deterioration of sugar, further production of cycle of sugar lasts 4 to 5 months, December to April, and the supply of the sugar produced during these months is being done round the year, your lordship. And hence the quality of sugar packed in jute bags deteriorated during the period, especially in raining season. Your lordship, that para number 7, the strange reality of this case, your lordship, is laser that is not disclosed by my learned friend, that is laser BIS licensed supplier. There is only 3 suppliers, your lordship, that is on record. Only 3 BIS issued license suppliers as on 31st December 2023. Only 3 license supplier of BS standard jute bags. The jute industry was not in a position to supply the huge quantity to the sugar industry. So, my lord, fact is they are incapable to supply huge quantity of BIS standard of jute bags. Your lordship, please come at page number 34. Page number 34 is the office memorandum, Ministry of Consumer Affairs, Food and Public Distribution, Department of Food and Public Distribution, that is issued on 3rd December 2024. And lordship, page number 34, para number C, that is line number 14, your lordship. C-type liner jute bags. This is the crux of this case, your lordship. C-type liner jute bags are compatible for packaging of sugar, and the jute industry do not have the sufficient capacity to meet the requirement of the entire sugar industry. They are just incapable to do all these things, your lordship. And my lord, the reality of this case is we are concerned with the jute industry itself, but at that same time, Your Lordship, we have to be concerned with the sugar industry also. So reality of this petitioner is nothing. They did nothing in this messy situation, Your Lordship, and that is para number 9. UP, kindly just UP State Cooperative Sugar Federation, Tamil Nadu State Cooperative Sugar Federation, and other sugar mills have floated several tenders, Your Lordship, to procure jute bags, but no bidder submit their bid to supply the jute bags. This is the fact of this case, Your Lordship. And the one sugar mill informed that they have placed the order to supply the jute bags 8-9 months before, but the same has not been supplied by the vendor company.
Where are you reading from?
That is para number 9, Your Lordship, page number 3.
Page number 3.
My Lord. Page number 3 of the submission, Your Lordship.
Yes.
That UP State Cooperative Sugar Federation, Tamil Nadu State Cooperative Sugar Federation, and other sugar mills have floated tenders to procure jute bags, but no bidder submit their bid to supply the jute bags. This is the glaring fact of this case, Your Lordship. Also, the one sugar mill informed that they have placed the order to supply the jute bags 8-9 months before, but the same has not been supplied by the vendor company. So far, copies of the letter emails are annexed. Now, Your Lordship, please come page number 37. Your Lordship, it's a letter issued by Sri Chhatrapati Sahu Sankara Sahakari Shakar 37, annexure 4. To the Secretary Indian Jute Mills, Your Lordship, we refer to inquiry for supply of jute bags in the month of October 2024. We wish to inform you that we have floated inquiry to follow list of jute mills. These are the errant jute mills, Your Lordship, who didn't follow any rules and regulation, Your Lordship. And they are not interested to follow the JPM Act 1987 itself. They are Uma jute mills, second one Premchand jute mills, then Assam, there are a number of 10 jute mills are there. Till date, we have not received any response from those jute mills. And you are requested to look into the matter and resolve the issue at the earliest. That letter is written on 30th December 2024. And what has been done by the petitioner itself? My simple question before Your Lordship is, they did nothing.
Just what authority does this person have, the managing director of this SSSK Limited?
My Lord, this is
cause for this inquiry.
My Lord, it's a sugar mill. They are just referring that they are referring these jute mills. They floated orders, and the orders had not been complied with all these jute mills. They are putting their names also. And this association, who is just a caretaker or who is acting on behalf of all the jute mills, have done nothing, Your Lordship. Now, Your Lordship, please come next page. That is page number 38. Then another jute mill is there, the Cathal Cooperative Sugar Limited. Your Lordship, that point number 3, quantity of jute bags, 60,000 numbers. And what is the result? That is number 5, quantity of jute bags received nil. Quantity of jute bag received nil. Jute mills are not supplying these. Again, page number 39, Your Lordship. That is last 5th line from the last one, that out of which the dispatch of nearly 8,000 bags is still pending since from 8-9 months. So now, Your Lordship, that page number 49, again the Kalka Kruchi Cooperative Sugar Mills, they are floating tenders. With reference to the above, we wish to submit that we have enclosed the details of tenders published by Sugar Cooperative in financial year 2023-24 and 24-25 for purchase of gunny bags in the prescribed format as called for GOI. Your Lordship, that is quantity awarded and PUH cancelled as the firm not accepted the payment schedule. And in the year 2024-25, no bidder has quoted for the rate of the supply of 50 kg jute gunny bags. They are least interested to supply these bags, Your Lordship. And last one, Your Lordship, that is page number 50. Subject is furnishing data for tender published by Sugar Federation. And in the year 2024, number of bidders nil. In the year 2024-25, number of bidders nil. And retender, number of bidders nil. Now, Your Lordship, I am going to conclude my submission with Your Lordship that the petitioner should honestly participate in the tenders published by the Sugar Federation, sugar mills, and cooperate with all the stakeholders and encourage the jute mills to upgrade themselves to produce BIS standard, cost-effective C-type liner jute bags suitable for sugar industry to make themselves relevant in the packaging industry. And Union of India is fully trying to just ensure 20% of the total production of sugar is to be mandatory packed in the jute packaging materials as per JPM Act 1987. And jute mills and gunny traders should stop cartelization to charge higher prices for jute bags from the sugar industry. That's my humble submission.
Is there any rate fixed as to what should be the rate for the jute bags?
Jute bags rates.
How can they inflate their charges if there is a fixed rate?
My lord, it's the problem. This is the very problem of this issue, my lord. They are not supplying due to huge demand. They are if prices are goes on.
Is there any fixed price at which the jute bags are sold?
Yes, there is, my lord.
There is a fixed
My
price.
lord.
If that be so, how can the association or the
My lord,
members they cannot charge higher than what is the fixed price?
My lord, then
isn't
they
it?
are refusing. They are not participating in tenders. They are avoiding tenders.
Very well. Now tell me, I just want to know what
My
can be the reason of these jute manufacturing bags for not participating in tenders. What will they do with the bags? They are making these bags not for the purpose of keeping them in their godown.
My lord.
They are making it for the purpose of selling it.
My lord.
Then why will they not do it? What can be the mens rea of not participating
My
in
lord,
tenders?
My lord, fact is only 3 companies are just BIS licensed supplier. Only 3 jute mills. So there are less number of jute mills who are BIS standard supplier of this jute bag. They are incapable to modernize themselves, and they are not in a position to provide C-liner jute bags which are required for the sugar industry. They are not upgrading themselves, my lord.
What steps are you all taking to make them upgrade their machineries, their working condition, the quality of the materials that are produced?
My lord, jute industry has to take the cognizance of all these issues, and they have to act accordingly, my lord. We are writing letters, and if there is any problem, they have to let us inform.
Lordship sees page 37, the first complaint, page 37, from Sri Chhatrapati Shahu, Shahukari Sakhar Karkhana. We refer to our inquiry for supply of jute bags in the month of October 24. We wish to inform you, we have floated inquiry to following list of jute mills. Last one, can you see number 10, Shaktigarh, happens to be one of the committee members' jute mill. Till date, we have not received any response. Kindly see. Here is the email correspondence I've handed up to my lord. 18th October. On same day, there was response from Shaktigarh.
That's
same day.
Only one.
Same day, naming 4 ISO certified jute mills which can supply the jute bags. Can you see at the bottom, with reference to your below mail, we introduce ourselves. We understand that you are buying jute bags for packing of sugar bags. One of the biggest manufacturer of all types of sugar. So our company operates 4 jute mills ISO certified, namely these. With total production of 400 metric tons per day. We are regularly supplying jute products to the domestic and international market. It will be a pleasure to receive your inquiry of jute bags for packing of sugar. We assure you to provide the best quality. Complete silence thereafter.
And is it the C-liner or what?
Yes, that is the
C-liner.
Lordship kindly sees this page 116 of the writ petition. There is a BIS notified standard for C-liner, page 117. Line
Page number 117.
Page 117. This is the Indian standard. This company alone had 4 mills.
Did this company participate in the tender processes?
No, there was no tender. There was a mere inquiry. Are you willing to supply? Immediate response was, we are more than willing. We've got 400 metric tons production per day. We have 4 jute mills who can supply. We please place your orders. There was complete silence. Complete silence thereafter.
See, there are certain reasons mentioned in paragraph number 4. For non-using jute bags.
This is Lordship kindly sees the page 127 of the page, sorry, 126 it starts at 127. Type C jute bags.
Yes.
for 50 kgs and different sizes can be there.
Hmm.
Type C with a liner.
Hmm.
There is a BIS specification and jute mills have the, and one company, the committee, the vice chairman's company, he has 4 jute mills who can all produce. And this is a BIS specified standards type C, at least 40 jute mills can produce this. And my lord, it is very unfortunate that they are espousing the cause of the jute for the sugar industry on the same breath as the while they are saying violation. Kindly notes, the sugar industry tried their luck against the jute in Karnataka High Court, citing all these problems. And kindly see the outcome of the writ petition up to Supreme Court.
No, thing is, the report that they have filed, they admit that despite all the negativities with regard to the jute bags, they are not taking away the 20% mandatory requirement of packaging. They are not.
Exactly.
Right. So this 20% is required to be followed.
Of this report. It is just the reverse. They are saying that the sugar industry is not willing to buy. Logically, see page 39. He's saying, I did not participate. Can you see page 39? The first paragraph itself. With above reference and received sugar directed letter dated so-and-so and jute commission letter so-and-so on the above cited subject, in which instructed that all sugar manufacturers are required to comply the direction regarding packaging of 20% of the total year's production of sugar and jute bags in upcoming. In this regard, we have packed 27,000 quintals of sugar bags of our crushing season 2024 sugar production by procuring jute bags on such a very higher cost in comparison. It is higher cost, no doubt, but this is a dying industry and trying to sell out since just after closing season for March continuously, but out of which the dispatch of only 8,000 bags is still pending.
Still pending. That has not
they have
been
already
supplied.
packed 27,000. They can't dispatch it after 8-9 months of its production due to no buyer is ready to purchase the same in the sugar market. So their problem is the buyers don't want to purchase this in the sugar market. It is not that we are unable. There was 27,000 quintals were packed, and they took. And at least 9 tenders of recent times I have got here, in which we participate, immediately they cancel. I've got a set of 9 tenders recently where we participate and they cancel. This is in the notification one by one I can show.
My lords, we are representing the sugar mill, my lord. We are representing the sugar mill. We are yet to file any document in this matter. Ultimately, my lord, whatever is the outcome of the writ petition, we would be the person who would be required to buy these, my lord.
Are you a party?
We are not a party, my lord. We seek, my lord's leave to intervene by way of filing an application, my lord. We were a
party. Leave is required. You can file your application.
Lord, we have just been able to know about this. That is why, my lord, we seek my lord's indulgence so that my lord does not pass a order against us as of now, my lord, so that we can become a party and make our submissions, my lord, because it is we who would ultimately be affected by whatever is the outcome of this petition, my lord. We would be the buyers, my lord.
So we are the government notification. The sugar industry tried their luck in Karnataka High Court, challenging the notification. We went and resisted
20%.
20%.
That was challenged. That was challenged.
That was challenged, but it was turned down very recently in Karnataka High Court. And SLP dismissed from that. SLP dismissed from that.
A lot of things are being said, my lord, which are not on record. Mr. Mitra, please.
No, of course, I'll give you the judgment because this is something they've come up with.
Lord, this, what I have been told, Lord, this Karnataka High Court matter, it is listed for hearing on 18th of March, Lord. It is probably something has come back, Lord. I also seek further instructions and seek
Kindly
to
see the
make
order.
detailed submissions before, Lord.
So Karnataka, they were unsuccessful getting any interim order. Now she kindly sees the division bench judge.
But what I can understand is that this season, there is no scope. We are in the first week of March. If the matter goes on like this, obviously by April, it cannot be done. So we have to wait for the next season of sugar.
So let them implement it now, as I said, because there is no stay of that government.
No, it's all right.
So they have to implement it. And they've tried their luck in Karnataka. They couldn't snap interim order from the trial court, set aside in appeal, upheld in Supreme Court. This is my judgment. So now they can't say that I will not procure jute bags and take up these frivolous pleas that the jute industry is not willing to supply. They have to implement, so long as notification is there. And I'm sure that the Directorate of Sugar has informed some sugar mills and got them to support. This is unfortunate. Government makes the notification. Government makes the order for supply in jute bags. And they are on one breath, they're asking the jute mills to comply. On the other hand, on the sugar mills to comply.
Actually, I'll make only one short submission.
Yes.
May I say this, Madam? This entire petition has been moved on the basis of Jute Packaging Materials Act. But under that act, your Lordship has been pleased to see paragraphs, clauses 6, 7, and 8.
Sections.
These are to be enforced. And the government has been given the power. If your Lordship take
Lordship has the act, but then I can give another copy.
No, if I have it, then please do not give a second copy. It will multiply papers.
If that act is there for your Lordship.
We had handed up by
para 6, 7, and 8.
Yes, jute packaging materials.
Yes, power to call for information and samples. These are the things, my lord, which are to be these are the thing enforcement. Central government, your Lordship has got it, my lord?
Yes, yes.
Power to call for information and samples. The central government may, by order, require any person who is required to use jute packaging materials for packing under Section 5 to furnish for the purpose of this act such information. Then power 7. Power to enter and inspect. Any officer authorized by the central government, hereinafter referred to as the authorized officer, may enter at all reasonable times any place premises. Then Section 8. Power to search and seize. The authorized officer may, if he has reason to believe any commodity has been packed in contravention of Section 5 and 6, 5 and is secreted to any place, premises, or vehicles, enter into and search such place, premises, or vehicle for such commodity. Now, what I'm on is this. These are the powers of the central government. Central government, in exercise of this power, had issued that notification of 16th May 2015. 16 June 2015.
Page 181 of the writ petition.
Your Lordship, my lord, has got a copy of that. There, my lord, your Lordship has been pleased to see the central government has authorized these persons. A, Jute Commissioner, B, Joint Secretary, then Deputy Commissioner, then Deputy Directors, Chief Director, Sugar, DMs, Collector, DCs of all the districts in India, and then my lord, SDM or SDO of all subdivision or all districts in India. Now, my lord, and these are powers kindly similar to third column, Section 678, all this power. Therefore, my lord, Jute Commissioner is only one authorized person by the central government to, my lord, enforce this. Now, Jute Commissioner, my lord, the equal power has been given to all: Joint Secretary, Policy, Deputy Jute Commissioner, Deputy Director, Chief Director, DM, Collectors, all, my lord, have been given the power. Now, my lord, if a person is aggrieved by the non-implementation of the provisions of the Act or any of the notifications issued thereunder, then, my lord, what is he to do? He is to approach that particular authority, the relevant authority, that look, within your jurisdiction, these persons are contravening the orders, contravening the provisions of the Act. Therefore, kindly take steps. Number, you come to Jute Commissioner and say you do this, and my lord, the infractions that are happening in UP and Maharashtra, and Jute Commissioner is sitting in Calcutta, how is he going to enforce this? Well, I think, my lord, this is I ask this question to myself. This particular provision, 80% food grains, 20% sugar, this was introduced in 2022. Why is it that my learned friend's client managed to wake up from the slumber in 2024?
I think throughout.
The reason is that, my lord, so long the jute bags which were being produced were all used by food grains. And, my lord, sugar was completely neglected. They were not being able to produce so much of jute bag. That is why they never raised any complaint. Today, there is some amount of, what shall I say,
Excess production.
Excess production. The result is this: they find one. They do not know what to do with this. These jute bags. The difference between sugar and food grains is this: the jute bags for sugar has to have the lining. If you do not have the lining, because my lord, of the sticky substance, the sugar, moisture, it my lord catches moisture and immediately, my lord, it becomes completely lost. That is why, my lord, this particular attention has to be given for the purpose of production of, my lord, jute bags for sugar. This, my lord, had not happened. And as I can see, this is something, my lord, which I found from the report which has been filed. The last, I just cursorily went through it. The page 49, I find, my lord, the e-tender called for by Tamil Nadu Cooperative Society and no bidder has quoted the rate. So who is to quote the bid? My lord, friend's clients. Mr. Mitra's client. Well, there is no bidder. Then, my lord, so, my lord, I just asked this question. Look, these are facts, my lord, which I am not in a position to tell your lordship on behalf of the Jute Commissioner. These are facts which are to come up. And I am sure, my lord, the government is there. My learned friend is there. Let these facts come up as to why is it so happening. I am as much interested in seeing, my lord, that jute bags are used for the purpose of packing sugar as my learned friend's client is. But the point is this: I do not know how to control this. And sugar is manufactured, as I told your lordship, in UP and Maharashtra mainly, and some in the south. So, my lord, how the Jute Commissioner will be able to, I'm sure, my lord, my learned friend's client will be able to do something about it. My learned, Mr. Mitra has given a suggestion. I have just now looked into the suggestion. I have not taken any instruction from my client. So I will not be in a position to tell your lordship, my lord, what are the problems in this. But it seems, my lord, there are multifarious problems, my lord, concerning this particular industry, this jute industry. My lord, government is trying to keep it alive. We are as much interested to keep it alive. But for some reason or the other, it seems, my lord, that what was being conceived of in the act and in the notification are not being complied with. Whose fault is it, my lord? I am not sure. I am appearing to the Jute Commissioner. I will not make any comment with regard to that. But it seems, my lord, that there are, I should say, remiss on both sides. Something has to be done. Perhaps this particular suggestion which my lord friend has given, this requires consideration, no doubt. But then again, my lord, I think, my lord, we will have to sit down together and try and find out a solution. This is not the solution, my lord. I am not here in an adversarial litigation in that sense of the term. Appearing for the Jute Commissioner, I am as much interested in keeping the jute industry alive as my learned friend is. Therefore, my lord, I would invite suggestions for the purpose of settling this matter. But this is not the way. But my learned friend, Mr. Appearing for the government, my lord, he has, in paragraph 4, he has said the reasons as to why this sugar is not, sugar industry is not welcoming these jute bags things. But, well, I submit to your lordship, this is not the forum for deciding that. This is a matter of policy. The government has formed a policy that 20% will have to be packed in the in jute bag. Neither my learned friend nor am I entitled.
Very well, please come.
From page 188 onwards, from 2014, we are objecting. We are making representation. Not a single letter from them that you are not procuring.
I've heard the submissions made on behalf of all the parties. Stop. The report of the Ministry of Consumer Affairs, Food and Public Distribution has been placed in details. Stop. It appears therefrom that the Sugar Control Order, 1966, prescribing packaging of sugar, packaging of 20% of the sugar in the jute bags is a mandatory requirement. Stop. The central government is required to ensure that the mandatory provision is complied with by all stakeholders. Despite the fact that there may be challenges in packing sugar in the jute bags. Stop paragraph. The petitioners association have brought to the notice of the court that there is enough production of sea liners, BIS certified jute bags, which can be used for packaging of sugar. Stop. The jute industries can always participate in the open tenders that are floated by the sugar mills for purchase of jute bags for packaging of sugar. Stop. The hearing of the writ petition stands adjourned to allow the parties to file their affidavits. Stop. Let affidavit in opposition be prepared and circulated by 4 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention.
Give some direction on them to implement it. You can kindly.
I have mentioned that the central government shall ensure that this 20% is followed. This has been mentioned. But then I don't know.
My intervention may be recorded, my lord. Lord, I am appearing on behalf of the Indian Sugar and Bio.
I am not recording your intervention. You can file an application which will be considered.
Mindful to. Grateful.
Deeply.
এটা কি দিলো রেখে দিন।
Number two is my application. It's a very short matter, but the consequences are very grave. Number, my client has filed an application under section 125 CRPC before the London trial court, which was dismissed in 2012 against challenging that order, my lord. A CRR was filed before this honorable court. On my lord, 23rd December 2016, this honorable court set aside that order and remanded the matter back for fresh hearing. The proceeding is sent on remand for considering the prayer of the petitioner towards claim of maintenance, etc. Now, my lord, after this, the file could not be traced. My lord, I had made a
which file? CRR file?
No, the criminal case file before the trial court.
Cannot be traced.
Cannot be traced for the last 8 years. But I made an RTI application. Lordship kindly sees page 21. Page 21.
Yes.
Whether the lower court record was called for by the High Court? No, lower court record was not called for. Then, my lord, third one, whether copy of the judgment and order dated so-and-so passed by Honorable Justice Devi Prasad De has been forwarded to the Additional Chief Judicial Magistrate, Durgapur. The judgment dated has been sent to Additional Chief Judicial Magistrate on 21st February 2017. So the judgment of this honorable court was sent to the with those directions. In spite of that, for the last 8 years, the file could not be traced. At last, I filed a put up petition at page 25. This is my lord on 15th January 2025. That the case was filed before the Learned SCJM at Durgapur in the year 2010. That the record was somehow misplaced and not been found for a long time.
No order has been passed on this
no order could be passed because the file could not be traced.
Who is this? The High Court party
yes,
here?
High Court is the main party. I have served the High Court and the upgradation notice is also here. But only
my lord, I appear on behalf of respondent number 1 and 2. Now, my lord, kindly, my lord, comes to page 21, my lord, his reply to his application under RTI, my lord, no LCR has been called for by this court.
Yes.
Therefore, my lord, there is no record in our department.
Yes. No, that he is all right. But then you inquire from the district registry as
guided by CRO, my lord.
yes. They may be guided, but then what about the file?
File, my lord.
Who are you for? State. Inquire what is the position of the file for last 8 years. 125 petition, the lady will perish, isn't it?
Let initial direction be passed upon the district judge.
But this is the party and he has been served.
Yes, district judge
Judge is
has
respondent
to
number 3 and the SCJM is respondent number 4. Both have been served.
I also have to inquire from the district judge because district
May
judge.
I submit this way, my lord? The district judge and the SCJM are under the High Court administration. So the High Court administration to file a report.
High Court, they are guided by CRO.
No, that is all right. But the
Superintendent's power only.
Please come.
But my affidavit service and updated.
Yes. The petitioner alleges that the case file of the miscase number 151 of 2010 within bracket Shipra De versus Pradeep De, which was pending consideration before the learned ACJM at Durgapur, is not traceable for the last 8 years, for which the petitioner cannot proceed with the subject case, which has been filed under section 125 of the CRPC. Stop paragraph. The respondent number 2 is directed to obtain a report from the respondent number 3 and file the same before this court with regard to the case file of the case mentioned herein above. Stop. Such report shall be prepared and circulated by 25th of March. Let the matter appear in the list on 28th of March. Affidavit of service and the notice of the learned advocate be written with the records. Notice of date দেখে নেবেন।
May it please
appear for the state.
May it please your lordship, in this matter I am appearing for state petitioner, my lord.
What is the matter?
My lord, I'm pressing the CAN application, my lord, because also the main brief.
Your CAN appears to be equally voluminous as your writ petition. Why is it so? You've put all your papers over here or what?
My lord, the annexures are more or less same.
Repeated, why?
My lord,
That is not the way.
my lord, that is.
What have you mentioned in the CAN?
My lord, exactly the matter only with the prayer for stay of the proceeding. My lord, this CAN application was filed for the purpose that a notification was there that if a stay application is made, then the matter will be listed within first 50 matters. Very frankly.
And so you file all the papers with the writ petition along with the CAN.
My lord, otherwise.
Absolutely bad practice. What is your prayer in the writ?
My lord, I'm pressing the CAN application because, my lord, our briefs, my lord, other side and also my brief, page number 12 and 17 are missing. So I'm pressing the CAN application, my lord.
Which page? CAN which page?
My lord, page number 34, my lord, 37.
Yes.
37, my lord. My lord, on July 15th, a complaint was made to the respondent number 4 by name, my lord, and which was registered as a complaint under section 9, which will appear from page number 39, my lord.
Yes.
My lord, the complaint has been filed on 15 July at page number 37, my lord.
Yes.
Which was received by the under the seal of the respondent number 2, named and sent to the respondent number 4, not to the respondent number 3, my lord. And that has been received by under the seal of the respondent number 2.
I didn't get it.
My lord, page number 37, my lord.
Page number 37, yes.
My lord.
to Shumita Mukherjee, the presiding officer.
Of
Your prayer is for dismissal of the complaint.
my lord, dismissal of the complaint, and also the constitution of the committee is bad in law.
Why is it bad?
My lord, I will try and satisfy your lordship on that point, but before that, my lord, this at page number 37.
Yes.
There is a material irregularity because the complaint was made on 15 July, before which was received by respondent number 2, the seal of the respondent number 2, that is the labor commissioner.
All right.
And that has not been made to the respondent number 3, which is the committee.
All right.
And my
So
lord,
you should go there before the committee.
my lord,
You should go before the committee.
my lord, I have raised this, I have made the petition before the committee, and the committee rejected it without looking into and without
Now you are challenging the refusal by the committee.
No, my lord.
What is the challenge?
My lord, the challenge is first the the complaint which was made on 18 July that has been registered on 16 July, and this complaint at page number 37 has been completely suppressed, and that has not been served upon me, and a complaint at page number 39 which will show that the complaint was registered on 16 July, my lord. By 16 July, at page number 39, the complaint has already been registered, which was not been made to the neither to the respondent number 3. That has not been made to the respondent number 3.
Oh, is it your case that prior to registering the complaint, the case was lodged?
My lord, first case is, my lord, the complaint was not made to the committee, and that has been registered. That was not addressed to the committee, and that committee registered the complaint under the erroneous assumption that that complaint was made to the committee, and that has been received by the respondent number 2, which was not been addressed to the respondent number 2, but the respondent number.
Are you the person against whom the complaint has been lodged? This is the reason you want to stand in the way of proceeding
26
with
hearing
the...
dates, 26 hearing dates, 3 repetitions including this. This is the dilatory tactics he has been. He is not allowing to complete the proceeding. One lady, a colleague has come up with a complaint against him, and he is not allowing to complete the proceeding.
My lord, allow me.
This is the third round of litigation.
My lord.
And 26 dates of here, I will show from the record.
Yes.
The complainant has suppressed on, my lord, your lordship will find from page number 37 or the complaint that on 10 July an incident has happened, my lord. My lord, may I hand up, which is on record, which...
But why will the court look into all these things? The ICC is there, the ICC will
my lord,
see.
my prayer is the biasness of the respondent number 4. Respondent number 4.
Let the proceeding be over. Thereafter, if the order goes against you, you do not know.
Appeal provision is there.
The constitution is also bad in law because, my lord, under section 4, my lord, your lordship knows better than I do, my lord, that a person is required to who has actually expertise in sexual harassment and women. No member is there. And also at page number 40, my lord, the constitution allegedly under section 4 of the petition, my lord, that constitution does not contain any guideline to be followed, any procedure to be followed. Even some orders are passed without the consent and the presence of the independent external committee, which will also appear from page number, my lord, 45, my lord, without 55, my lord. The orders have been passed without the presence of the independent committee, my lord. My lord, my specific case is that, number 1, my lord, the constitution...
What were the earlier writ petitions about?
My lord, 2 writ petitions were filed. One was due to the transfer, my lord, and another...
Transfer of?
They have transferred me in course of the time. During this proceeding, I have been transferred to 500 kilometers away from my
Workplace.
to my
Yes.
workplace. That was one writ petition, my lord. And another writ petition was, my lord, I filed, the complainant was allowed to file a reply, and to that reply, I filed a rejoinder, and that rejoinder was, without looking into that, the rejoinder was straight away rejected.
Yes.
And challenging that order.
At that point of time, you did not challenge the constitution.
No, my lord.
Right. And after all these years, after 26 hearings
Because
being
my-
conducted, you suddenly say that the constitution is bad.
It's not, my lord, years, my lord. Even, my lord,
26 hearings being conducted.
my lord, 26 hearings, not only the complainant's witness and only the complainant. Let them file it. 26, only I got 4 dates. Since December, I am in the picture. Before that, the complainant and the complainant's witnesses, they were all over. Since December, my deposition started, and just because of the fact that the order dated 7th, I made a petition for time to challenge the order dated 7th February. I have been faulted just because of that fact, and my deposition has been closed without giving me the opportunity, and the matter is fixed for cross-examination, my lord. And my lord,
Yes. You will have chance.
my lord, I am, my lord, under specific instructions, my lord, which will appear from my prayer of the writ petition, my lord. My specific prayer is that I am ready to take part in the proceeding, but I reasonably anticipate that this respondent number 4 is biased against me, and also there is a reason because which my lord will kindly take up section 9, my lord. My lord, section 4, my lord. My lord, whether any disciplinary proceedings has been committed or not, has been commenced, whether any proceeding has,
Disciplinary proceeding is something else.
my lord, that
And the proceedings under POSH is
my lord,
different.
under POSH Act section 4 of the POSH Act 4(5), my lord, there is a mandatory provision that any proceedings against the presiding officer or the member, if it's there, he or she should not be there in the committee. And this is also a case, my lord, which
So against whom is the disciplinary proceeding pending?
my lord, not pending, my lord.
Then
proceedings were there. 2 proceedings under instructions, my lord. 2 proceedings were there. One of which presiding officer, the present
when was the complaint lodged?
My lord,
And-
page, my lord, 37, my lord, of the writ petition.
37, yes.
Of the writ petition, my lord.
Right. 16th of July 2024.
16 July 2020. This is the, my lord, first complaint lodged by, kindly see the contents of the. Now, my lord, his primary objection is why this lady had addressed it to internal compliance committee. Why not complaints committee? That is one technical objection. Kindly see
It's internal complaint committee.
compliance. It is written page 30.
Compliant.
Yes.
It's
And why it has been addressed to the presiding officer lady, not to the ICC.
I understand.
Lordship. So on this, that was a complaint. So when this lady approached with this particular complaint at page 37, what the ICC does, ICC tells her that your complaint is not in accordance with law. You are to do it in accordance with law. So, my lord, then comes page 39. So now, this starts, my lord, this proceeding starts on and from 18th July 2024. This is the instruction. Kindly, lordship. 18 July. Kindly seize, my lord, the first page of the instruction, 1, 2, 3, third paragraph. Upon the advice of the respondent 3, respondent 6 submitted the complaint on 18 July 2024, and this is considered the initial complaint in respect of case number so and so. So 18 July was the date of initiation of this complaint. Now, my lord, what this gentleman does, may I specifically, so he wants quashing of this particular proceeding in the writ. Kindly have a look at the prayer clause, my lord, at page 33.
Page 32, my lord, mandamus to recall decedent, the impugned notice 16th May, and quashing of the instant proceeding. This is one of the reasons that it was technical. Second, in paragraph 6, he says that this presiding officer, who is one of the members of the ICC, is due to retire. Kindly see paragraph 6 of the writ petition. It appears from the memo number so and so dated so and so, wherein the respondent 3 consists of 4 members, wherein respondent number 4 has been named as the presiding officer and respondent 5 as the external member. It appears from the said memo that the presiding officer and every member of respondent 3 shall hold office for 3 years from the date of the order dated 16 May 2024. Therefore, as per order dated 16 May 2024, vide memo number so and so, the respondent 4 shall hold office of the respondent number 3 till 15 May 2027, whereas the date of retirement of respondent 4 is November 30, 2020. What is your problem? She might retire. Again, somebody else will take. Because why he says this? Because section 4 of the POSH Act says that presiding officer and every member of the internal committee shall hold office for such period not exceeding 3 years. His count is that she is going to retire before that. Why she is there? This is one of the. For this, now, Miller, may I respectfully invite your lordship the stay application, the CAN application. Kindly see what is this challenge. May I respectfully invite your lordship to the page 30 of the Miller CAN. Kindly see the prayer.
Setting aside.
Setting aside 2 orders. One is dated 7th February 2025. Lordship will get it at page 46 of the application. Kindly see page 46. This is the order where we dealt with his maintainable petition and rejected, which he is telling that I preferred an application for maintainability. That was not. So this is the order, my lord, which was passed on 7th February 2025. Kindly see. Mr. So-and-so impugned a letter bearing number so-and-so enclosed, submitted. So this is the order. Kindly see, my lord, the page 47, my lord, is the ordering portion. From facts and circumstances stated above, it appears that Srimati Uma Noshkor had raised an issue relating to sexual so-and-so on 15 July. Now, since the complaint was not as per Rule 7.1 of the POSH Act, the committee had advised her with a so-and-so dated 16 July to file a complaint as provided under relevant rules. Section 9.1 of POSH Act says the presiding officer or on any member of the internal committee or the chairman or any member of local committees maybe shall render all reasonable assistance to a woman for making the complaint in writing. Therefore, the letter dated 16 July 2024 has been done as per provisions of the Act. Upon advice of the ICC, Srimati Noshko submitted the complaint on 18 July 2024 and as the initial complaint on this as per section so-and-so. Regarding the matter of addressing the committee as internal compliance committee instead of presiding officer internal complaints committee, the same appears to be a mere typographical error. Even Sri Majumdar had referred the committee as internal compliance committee on some of his petitions. However, the committee advises both parties to mention the name of the committee properly in future communications. Therefore, the petition dated so-and-so, submitted with so-and-so is hereby rejected. That was maintainable. Now, the second order we challenge is sent 10th February 2025. Kindly see, it is that page, my lord, 51, my lord, of the interlocutory application. This is 10th February 2025. What does it deal with, my lord? Kindly see, today, 10th February 2025 at 11, fixed for conclusion of deposition. So his deposition started. Respondent. Here from kindly sees, my lord, first to fourth paragraph kindly sees. From records, it appears the ICC had started the inquiry under section 11 of the POSH Act, dealt with Rule 7. Submission, written submission, after submission written statement of the respondents and thereafter rejoinder by the complainant hearing was started on 6th August 2024. Since then, 26 dates have been fixed for hearing of the case. Sri Majumdar remained absent and prayed for adjournment on 27, 1, 2, 3, 4, 5, 6 has been 7 days. Besides, the respondents had filed several petitions to the ICC on so-and-so dates for various reasons mentioned therein. All the above mentioned petitions had been heard in presence of both the parties, and reasoned orders were passed thereafter. Sri so-and-so responding in respect to ICC has moved to Honorable High Courts on 2 occasions. One is 22640 praying for discontinuation of the proceedings of the present ICC. Milord, that is WP 22640. Milord, I have respectfully, Milord, handed over to your lordship.
Yes.
He got this writ petition filed and finally got it dismissed for default. So what was the challenge? It's not clear from the order sheet, but here it says it was praying for discontinuance of the proceeding by the present ICC, to which this Honorable High Court dismissed it for default. And second was regarding his transfer, because in the POSH Act, Milord, it is provided for, it is contemplated that the lordship knows, Milord, he can or be transferred anywhere. Therefore, it is clear that Honorable High Court had not issued any order to discontinue the proceedings. Though ICC has been gracious enough to allow all adjournment prayers of the respondents so far from facts and circumstances, it is evident the respondent is trying to delay the entire proceedings somehow or the other. Therefore, the petition of Sri Dipanganja so-and-so is. Now, Milord, may I respectfully invite your lordship to the Milord, my instruction, Milord, at page, Milord, 2 of the instruction. Page 2, Milord, kindly sees, Milord, the authority while dealing with paragraphs 14, 15, and 16, it says that 10th February 2025 was the date fixed for conclusion and deposition of Sri Mukherjee, Majumdar, so-and-so. Majumdar submitted a petition on 10th February 2025, which had been mailed to the ICC on 7th May 2025 at 5:19 p.m., in which he had prayed for time to challenge the order dated 7th February 20 passed by ICC before Honorable High Court. The order in question relates to so-and-so, Milord. So this was the date. So this is the way he is, Milord, adopting dilatory tactics and I leave to your lordship, Milord. I leave to your lordship.
May I, my lord?
Yes.
My lord, at page number 55, the learned senior relied upon. Your lordship will see that the order was passed without the presence of the independent member, my lord. My lord, also at the same time, my lord, I will submit, my lord, that for reference to the police officer on other occasion, on earlier occasion, I have made a petition before this committee for referring the matter and for asking for report from the police authority.
Why?
Because, my lord, there has been some situations, my lord, which the respondent number 4 is not inclined to take up, my lord.
Please come.
My lord, my specific case is the biasness
The
of
petitioner is the respondent in a proceeding initiated by the authority under the Prevention of Sexual Harassment.
May I hand over?
এই বইটার নামটা একটু লিখে দিন তো। Prevention of Sexual Harassment of Women at Workplace ব্র্যাকেটে 2013 ঠিক আছে। The challenging the said proceeding, the petitioner approached this court earlier by filing WPA 22640/2024, which stood dismissed for default by the court on 27th November 2024. In the instant writ petition, the petitioner challenges the constitution of the ICC, Internal Complaints Committee, under Section 4 of the Act. It has been submitted that the committee has not been constituted in accordance with the provisions of the Act. The presiding officer of the committee does not have a full term of 3 years, and as such, she ought not to have been appointed in the said committee. It has been submitted that there is no proof that the members who have been appointed in the committee have experience of handling matters relating to sexual harassment. The complaints lodged by the petitioner, not complaints, request made by the petitioner for referring the matter before the police has not been accepted by the committee. prayer has been made to set aside the orders passed by the committee and to quash the proceeding initiated under the Act. Stop paragraph. From the report of the Joint Labour Commissioner within bracket P, who is also a member of the ICC, dated 21st of February 2025. It appears that the petitioner has all along been non-cooperative in the proceeding. Stop. There were as many as 26 hearings being conducted, but the petitioner all along tried to delay the matter. Stop. He remained absent on several dates. Stop. Next. The court is of the opinion that as the committee is a statutory committee under the Act, the petitioner would be bound to participate and cooperate in the said proceeding. Stop. The committee shall take steps in the matter strictly in accordance with the Act. The writ petition stands disposed of.
My lord, my deposition has been closed without giving me the opportunity to complete the deposition, and the matter.
You remained absent on so many occasions. What can be done?
My lord, this is not at all the case. Specific instruction.
The committee shall endeavor to dispose of the complaint. Now, to dispose of the proceeding initiated in response to the complaint filed by the complainant at the earliest, without granting any unnecessary adjournment to either of the parties.
My lord, my deposition.
No, nothing doing. If it has been closed, it has been closed.
May I take back
Can also disposed. Yes, book you can take back.
My lord, my deposition be completed, a chance, opportunity be given to complete the deposition, my lord.
Call the next matter, please.
Lordship, in this matter, Ms. Ponar Chaudhary appearing on behalf of the Punjab National Bank. She has engaged in courtroom number 1. Kindly matter keep it at 2 p.m. madam. She has engaged in courtroom number 1, madam.
What is your prayer?
Here I am challenging the notice issued under section 13(2) of the Surfacey Act. That is, my lord, page 101.
13(2) stage you are here.
My
Why?
lord, because the 13(2) notice, my lord, 3 loan account clubbed together, 1 notice has been sent
Yes.
to the borrower. My lord, if your lordship kindly see page 101, the 13(2) notice has been served, in which my lord, non-performing asset declared me on 29/1/2025. My lord, that is 4, serial number 4. That the date has been classified as non-performing asset on 29/1/2025. That was not sent to me.
Not
29, no NPA non-performing asset notice has been sent to me. No notice has been received by the petitioner.
Is there any requirement of giving further notice? No.
And my lord, on
No,
that,
nothing.
my lord, without giving any notice, without declaring my account as NPA straight away, the 13(2) notice has been sent.
It has been declared as NPA on 29th January. That is the date. There is no requirement of giving any notice.
My lord, NPA notice has been, my lord, has sent to the petitioner, my lord, that is borrower, my lord. If your lordship kindly come, the default means, that is 2 subsection I.
non-payment of any debt or any other amount payable by the borrower to any secured creditor consequent upon which the account of such borrower is classified as non-performing asset in the books of accounts of the secured creditor.
Where are you reading from?
My lord, that is-
Definition, my lord.
clause.
Definition of default.
Definition of default. And then non-payment of any debt or any other amount payable by the borrower with respect to debt securities after notice of 90 days, demanding payment of dues served upon such borrower by the debenture trustee or any other authority in whose favor security interest is created for the benefit of holders of such debt securities. And 3 accounts are there, 3 loan accounts. 13 to notice, then in one club together in one notice they send 3 accounts.
My lord, there is no bar.
No NPA has been declared, no notice has been issued, straight away 13-2. And my lord, if your lordship can see that 13-2 notice, my lord, there are specific provision as
See, the act says the notice under section 13(2) shall give the details of the amount payable by the borrower, the secured asset intended to be enforced.
that was not done.
Nothing.
Well, that is only done.
13-2 notice.
And see, there is a provision under 3A, 13(3)(a).
That they can
If
give
you
a
receive
reply.
notice, you can go there. Why have you filed the writ petition?
Lordship.
Because they did not disclose any
You have 3A.
statement.
You have got 3A.
I have 3A,
Then go.
I have 3A.
Why here? Please come.
Grateful to your lordship.
Malat with liberty. Because Malat
The petitioner
set on 7th.
challenges the notice under section 13(2) of Surfacey, dated 7th of February 2025. Stop. The act provides remedy to the petitioner under section 13 within bracket 3A. If the petitioner is aggrieved by the notice under section 13(2), stop. It will be open for the petitioner to avail the said remedy. Writ petition stands dismissed.
Lordship. Grateful to your lordship.
Dismissed.
Disposed of, my lord, with my lord,
What?
provision is there, my lord.
Provision is there. Why have you approached? Why will cost not be
My lord,
imposed?
3 accounts they send one notice.
Why will cost not be imposed?
Yeah, my lord.
No, liberty has been given, but it is dismissal.
Instead of dismissed, my lord, disposed of. Because my lord, this is
That.
disposed of. There is a my lord, other remedy is there.
Other remedies there you should not have approached here. No. No kindness. Dekhi 5 number.
Grateful to your
Thank
lordship.
you, my lord. Evidence service.
Yes, service.
Well, I'm for the respondent, my lord. I have raised a preliminary objection that this rate court has lack of jurisdiction, territorial jurisdiction.
Yes.
What's that?
Lordship, on the last.
Why lack of jurisdiction, you say?
Lordship, because the respondents, the situs of the respondents is beyond the jurisdiction of.
All right.
Honorable right. Lordship, in the writ petition, I wanted to file a supplementary affidavit. I've given a copy to my learned friend. If your lordship would permit, I'll give it to your lordship.
No, what do you want
tell your
to
lordship.
include in the supplementary?
Only the notices that have been issued to me where the venue of the hearing has been fixed at Calcutta. I just wanted to bring that on record. If it falls from your lordship. Only that annexure.
So relying upon that, you want to invoke the jurisdiction of the Calcutta High Court?
I will. I'll come to that, your lordship. But this
because
is
there is no other reason. All the respondents are
there
located outside the jurisdiction of the Calcutta High Court.
Admittedly.
Right?
Admittedly.
It is only the service of the notice. You stay here and the service of
the
hearing will be
has
held
been
here.
held in Calcutta.
All right.
All the hearings, and that is to that extent, I'm filing the supplementary.
Very well.
Now, your lordship, before I place a supplementary affidavit, lordship, the case of the writ petitioner before your lordship, what is impugned? The refusal by the commissioner information to give me certain information. Lordship, the writ petitioner before your lordship is a retired commodore of the Indian Navy. He retired in the year 2018.
Who is the SPIO? Is the SPIO is not a party here? Who is the person who is going to give the information to you?
Lordship, the CPI, the CIC, the respondent number 4.
Chief Information Commission,
Yes,
it
Your
should
Lordship.
go first before the.
I have exhausted, this is the first appeal, this is the second appeal. The second appeal has been rejected. And that is why I am before Your Lordship.
Yes.
And Your Lordship, what has happened is, the writ petitioner is a retired employee. He had suffered certain adverse remarks in his ACR. That was long back in 2007-8. Lordship, he filed an application before the Army Tribunal, Delhi. And the Army Tribunal said that the adverse pen picture should be struck down. But did not pass certain orders that will have a cascading effect and all that. He went to the Supreme Court. The Supreme Court upheld the order of the tribunal and said that the petitioner should be given his dues. He's an honest man, he has worked hard, he should be given his dues. Thereafter, Your Lordship, the entire saga starts. He started making, he was waiting for his promotion. The adverse picture, Your Lordship, he had suffered reduction in his numerical gradings. So after that, when the promotion board was constituted, he did not get his promotion. So he tried to find out why. And Your Lordship, he started making these representations. Then the Navy, Your Lordship, he asked, what is the policy of the Navy when the adverse pen picture is struck down? So are the numerical gradings not upgraded accordingly or reversed to what it was before the adverse pen picture? And Navy said, we have no rule. During that course, Your Lordship, he has retired. After his retirement from Calcutta, he has started initiating various applications under the Right to Information Act, asking for the policy, the Navy policy, relating to assessment of the ACR after the pen picture has been struck off, adverse pen picture has been struck off. And Your Lordship, these information has been denied to him under Section 2F of the Right to Information Act. And that order is before Your Lordship.
Yes, please show.
The impugned order, Your Lordship. The impugned order, Your Lordship, starts at page 180. But Your Lordship, that's the original order. I could not number it. It starts on page 180, Your Lordship. I will not trouble Your Lordship with the whole 180. Page 180. Lordship, I will not trouble Your Lordship with the whole factual aspect of the order, because Your Lordship will kindly remember I had sought only directions for filing affidavits. But anyway, I'll place before Your Lordship will kindly see. Lordship, the second last page. May I place the order before Your Lordship? What is the information that he is seeking? Lordship, the order being an original order, it has not been numbered.
Yes.
Lordship,
But then you are not required to give the original.
Lordship,
A photocopy would have been.
From the original order has to be annexed in the writ petition.
Original order has to be annexed. Which original order?
The impugned order.
None of the petitions they are annexed.
But Lordship, that is the rule.
No, certainly not.
That's it, because we cannot file a writ petition without the original order. Original order is being annexed.
Anyway, yes.
Lordship, will kindly come to the first page of that order. The appellant filed an RTI and dated 2/6/22 seeking the following information. Based on the CPIO's Navy reply, so-and-so, Lordship will kindly see 2. What is the policy of the Indian Navy of the ACR system of officers relating to the setting aside of the entire pen picture and consequently the entire report in an ACR, including numerical gradings by the reporting officers related to that specific pen picture by the reviewing officer and subsequent reporting officers up to the ACR chain. Do you have a stated documented policy? Please share the details, including the documents. Next, what is the Navy policy guidelines, MOD orders, regarding specifically setting aside of the numerical gradings that are related and integral to the pen picture written by the RO in a case where the entire pen picture by the same RO has been set aside by the order of a court or tribunal, similar to what is seen in my case. Do you have a stated documented policy? Please share the details, including the documents. Next, Your Lordship. Were the numerical gradings by the RD in my C command ACR of 2007-8 set aside once the entire pen picture by the RO was set aside by the above AFT order? On what date was the numerical gradings by the RO officially struck off from my ACR, and what notification was made in my service records? Please provide a copy of such endorsement made by the Navy with date. If the numerical gradings related to this entire pen picture by the RO was set aside by the Honorable AFT were not struck off, why was it not done? What was the basis, rationality? Do you have a stated documented policy? Please share the details, including the documents. What is the Navy policy guidelines orders regarding conduct of a review promotion board wherein the entire pen picture by the RO has been set aside by the order of a court, as is the case above? And what numerical gradings of the RO are then considered to arrive at the finalized ACR marks for that report? Lordship, in a nutshell, this is his repeated information, and there are 8 RTIs made by him. 8 RTIs where his cause of action is practically the same.
When did he retire from service?
In 2018.
18. And his first RTI application comes in
Prior to
2022.
Prior to this, he had made RTIs where he was informed that the ACR, the pen picture, there is a blank paper put over the pen picture. I have annexed that. He was informed by the Navy that we have put a blank paper on sheet over the pen picture, and that is all. By the time he got that information, that all that has been done in his ACR is that a blank sheet of paper has been placed on his on the adverse pen picture. He retired. So after his retirement, now he's asking for the policy. Lordship will kindly consider, here is a person who gets excellent 7.5, 7.6 in his ACR. Then an adverse remark which is not communicated to him. And that grading, Your Lordship, is lowered by 0.6. He misses his chance of being appointed as a rear admiral. He asks, what have you done? They say we put a blank paper on the pen picture. He asks, do you increase the numerical gradings? They say, no, we don't, because we have not done it. In that course, Your Lordship, he retires. After that, he makes these representations. And all these representations, right from the CPO, first appeal, second appeal, rejected on the ground of attracting 18.1J, 18.1E, and 2F. Lordship, this is the case before Your Lordship. Lordship, the question is that the respondent does not reside within the jurisdiction of this court. Your Lordship, the respondent is a central government authority. They have a presence all over the country. I'm a retired employee. Lordship, the entire Your Lordship I could read out the entire complaint, all the complaints.
I am looking at the list of dates when the cause of action arose. The ACR, concerned
Lordship, the ACR was 2007-8. Then he went to the AFT. And then from the AFT, Lordship, he filed before the Supreme Court. After the Supreme Court directed them to consider my promotion as per the changed profile, when nothing happened at the next promotional meeting, that was in 2014-15. I think, Lordship, that was in promotion at 2000.
At such a delayed stage.
Lordship, he's a man of honor. He has been working in the Navy. All he wants to know, Your Lordship, what is the policy decision? Lordship will be surprised that just lately, Just lately, Your Lordship, a coastal guard of the Navy has been arrested. It's all over the news. I have not brought it to Your Lordship. Because he was pilfering and he was with the ACR of his seniors and his juniors to ensure that he gets his promotion. Lordship, the entire policy of the ACR, Lordship, when
1 minute. Let me hear. Yes.
Yes.
Only with regard to the informations.
Regarding jurisdiction, I have to make some submission, madam.
Yes.
I have a judgment of the Honorable Supreme Court Three Judges Bench, wherein it has been categorically Supreme Court held that mere residence or doing business in particular in Calcutta does not get a territorial jurisdiction. That is the judgment.
No, that is the very first day I said the only residents will not do.
Madam.
Now, what has come up in the supplementary, I have not seen it, that the notices of hearings were given here. The hearings were taken place over here.
Can you see the supplementary copy? There is supplementary.
Were the hearings conducted here?
No.
Your Lordship.
No.
Yes.
What are hearing conducted?
Lordship will kindly see page
It starts from page 10.
10.
Page 10, yes.
Your Lordship will come to page 11. Venue for the appellant complainant.
Venue room number 313, Central Information Commission, Baba Gang.
Lordship, that is for the CPIO. Lordship will see the venue for the complainant. NIC studio call.
Video conferencing room.
Video conference.
Area New Town, Rajarhat.
On video conference, my lord.
The venue was all in Rajarhat.
Yes, but actual venue is for CPIO. Venue room number 313, Central Information Commission. And notice is from the respondents, CPIO Integrated Headquarters, Ministry of Defense, Navy, New Delhi, 11,011, my lord.
Yes.
So he appeared from here. It does not create any jurisdiction, my lord.
Lordship, the Right to Information Act. Lordship, under
Yes.
the Right to Information Act, Your Lordship, a duty is cast upon the authorities to have an office at every area, every district where they can reach out. May I place the Right to Information Act before Your Lordship? And that is why, Your Lordship, they gave me a venue.
This office has not conducted the inquiry, my lord. Hearing conducted from Delhi, my lord.
Lordship will
He just
kindly-
appeared from here.
Lordship will kindly come to
Actual
section
appearance.
5. Lordship will kindly come to section 5 of the Right to Information Act.
Yes.
Lordship, designation of public information officers. Every public authority shall, within 100 days of the enactment of this act, designate as many as central public information officers or state public information officers, as the case may be, in all administrative units or offices under it, as may be necessary to provide information to persons requesting for information under this act.
No,
So,
that means
Lordship,
somebody has to be designated as CPIO or SPIO.
That area, because
Yes.
they did not designate, they held it from Delhi and they put me on video conferencing. But Your Lordship, my hearing was from Calcutta, and I will place judgments before Your Lordship, Your Lordship. Article 226. Lordship, Article 226 specific previously was very stringent. It was only the citus of the respondent and the persons against whom the writ is called for. Their territorial jurisdiction. Article 226(2), Your Lordship, has been amended. It was amended in the year 1963. Thereafter, Your Lordship, there has been a continuous enlargement of the scope of Article 226. And Your Lordship, these honorable courts have held that where it is a retired employee, it would be a great hardship to direct that retired employee who's living on pension to rush to appropriate forums to file the writ. I'll place those judgments if it falls from Your Lordship.
No, because this is a serious objection that is being raised with regard to the
I just-
maintainability.
I am just
So you have to meet
three
it.
lines, just placing 2-3 lines.
You have to meet it.
Notwithstanding the strong observation made this court in the aforesaid decision in the earlier decision referred to therein, we are distressed that the High Court of Calcutta persists in exercising jurisdiction even in case where no part of the cause of action arose within the territorial jurisdiction. It is indeed a great pity that one of the premier high court of the country.
This is a very old judgment.
Very
It's
old
no
judgment.
use
Lordship,
repeating it.
may I place a judgment? Shanti Devi. Shanti Devi. 2020 Supreme Court cases. I'll give my learned friend a copy.
Yes.
Naturally.
আমি তোমায় দেবো একটা কপি আমার কপি
দাও, তুমি তো দিলেই না। Lordship will kindly come to paragraph 15. This is Supreme Court cases, 3-judge bench. And subsequently, Lordship followed by a number of high courts all over India. Paragraph 15, Your Lordship.
Yes.
The second reason given by the learned single judge that the petitioner ought to have filed a writ petition before the Jharkhand High Court also does not commence to us. For a retiree who is settled in Darbhanga and receiving pension at the district Darbhanga, it cannot be said that it was necessary for him to file his petition in Jharkhand High Court, where his earlier writ petition was pending. Lordship, for his pension, he had filed a writ petition which was pending, and after retirement, he files a second writ petition. And the court holds as such. Your Lordship will kindly come, paragraph 17. Mullah on the Code of Civil Procedure, while commenting on section 20 of the Civil Procedure Code, declined cause of action in the following words. Cause of action. The expression cause of action has acquired a judicially settled meaning. In the restricted sense, cause of action means the circumstances forming the infraction of the right or the immediate occasion for the action. In the wider sense, it means the necessary conditions for the maintenance of the suit, including not only the infraction of the right, but the infraction coupled with the right itself. Compendiously, the expression means every fact by which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to the judgment. Paragraph 18, Your Lordship. Cause of action has been defined as meaning simply a factual situation at the existence of which entitles one person to obtain from the court a remedy against another. The phrase has been held from earliest time to include every fact which is material to be proved to entitle the plaintiff to succeed, and every fact which a defendant would have a right to traverse. Cause of action has also been taken.
See, this is not something which is required to be traversed. It is also not required to be proved. You stay here. This is sufficient proof.
Yes,
There is
and
nothing
that
to prove.
And Your Lordship, that the hearing was held over here. Lordship, cause of action has also been held to be a minuscule part of the cause of action arising between the territorial. And Your Lordship will kindly come to the paragraph 20. Lordship, it has, Your Lordship, quoted the judgment which I think my learned friend has.
Yes, yes. ONGC judgment.
Clause 1 of 226 begins with a non-obstante clause, notwithstanding anything in Article 32, and provides that every high court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within whose territories directions, orders, or writs for enforcement of any of the rights conferred by Part 3 for any other purposes. Under Clause 2 of the Article 226, the High Court may exercise its power conferred by Clause 1 if the cause of action, wholly or in part, had arisen within the territory over which it exercises jurisdiction, notwithstanding that the seat of such government or the authority residence of such person is not within those territories. On a plain reading of the aforesaid two clauses of Article 226 of the Constitution, it becomes clear that a High Court can exercise jurisdiction, the power to issue directions, orders, or writs for the enforcement of any of the fundamental rights conferred by Part 3 of the Constitution, or for any other purpose.
Can you get hold of certain precedents where this online hearings and everything took place, which gives rise to cause of
If it
action?
falls me, your lordship, I will.
Because this has been objected to.
Lordship will also come to that page, paragraph 32. Just the conclusion of this judgment. And I will, your lordship, it falls from your lordship, I will bring those judgments before your lordship. As noted above, the learned single judge has also observed that the petitioner ought to have filed a writ petition in Jharkhand High Court, whereas earlier writ petition was pending. The earlier writ petition, which was initially fixed in Patna High Court, was for refund of the amount as noted above. After dismissal of the writ petition on the ground of lack of territorial jurisdiction, B.N. Mishra, that was his husband, had filed the writ petition in Jharkhand High Court for relief which was claimed in the writ petition. As noted above, the cause of action for filing the writ petition was entirely different. Stoppage of pension and asking for refund for more than 8 lakhs amounts and had serious adverse effect on the petitioner who was staying at his native place, Darbhanga. Lordship, this is very important. A retired employee who is receiving pension cannot be asked to go to another court to file a writ petition when he has a cause of action for filing a writ petition in the Patna High Court. For a retired employee, convenience is to prosecute his case at the place where he belonged to and was getting pension. The submission of the learned counsel for respondents 1 to 2 on the principle of forum non-convenience has no substance. And I will place your lordship, Domitus Litus today has taken a very strong concept, your lordship, where retired employees are concerned. Lordship, territorial jurisdiction.
Very well,
today,
come up with all those. Please come. Supplementary affidavit filed in court is taken on record. Stop. A very serious objection has been raised by the learned counsel representing the Union of India with regard to the maintainability of the writ petition before this court. Stop. Paragraph. When do I keep it?
Lordship, next week, lordship, someday.
Next
I'll have to
week.
check up.
List on 19th of March.
Lordship. I'm grateful, your lordship. I'm grateful, your lordship, for accommodating me on the last occasion.
My lord, I beg to appear on behalf of the writ petitioner, my lord.
Yes.
My lord, I pass an order dated 16th of January.
Order, my lord, appeal was preferred.
This is the final
division bench
order passed by
an
the,
order. Even yesterday, another order was passed, which is not uploaded till date. And my lord, the honorable division bench fixed the matter on 24.
kindly come to the paragraph 3 and 4 of
Why? The division bench has
kindly come
looking
to
at
my
the
lord.
issue.
Kindly
Why
come
does
to
court look?
my lord. There, I did for your lordship.
And my lord, the earlier
Find no,
order,
find no ground to set aside the direction passed by the learned single bench, permitting the petitioner to enter into the property and set it. So there is no interference by the division bench, my lord. There is no stay, my lord, passed by. There is no such direction binding upon the petitioner to allow the private respondent into their self-acquired property, my lord.
that is restrained by
What is the matter?
My lord, the writ petitioner is the father
your
and
lordship
mother
directed-
of the private respondent, my lord. The senior citizen
directed the respondent to
take
to manage his own shelter, and he will shift immediately from the parents' house.
All right.
And my lord,
kindly
that order
come
is
to the
challenged. And my lord, the honorable division bench
Hey,
bifurcated
kindly
this
come to the
order.
para number 3 and 4 of the order passed by the division bench.
no, it is all right. What you want? This court will pass orders when it is being fixed by the division bench.
Division bench has fixed to file an affidavit whether I have entered into the premises
the-
or not.
My lord, the earlier order
Ah.
passed by the division bench, I am handing over.
I have not able to comply the order of the division bench because of my illness, my lord. I am entering into the premises on 17, my lord. This is the affidavit filed before the division bench, my lord. Yesterday, my lord. And the matter is only fixed before the division bench to file.
But
an
yesterday
affidavit.
the matter was not taken up.
Yes,
My
yes,
lord.
my lord. Yesterday,
Oh, yesterday another order has been passed.
yes.
And there
Because
is
they took the time
Fixing on.
on 24th.
All right, please come.
My lord, there is no such direction to upon the
They
The
did
order
not comply
dated
the order of the
19th
division bench.
I am entering into
February
the premises on
2025
17, my lord.
and the order dated 3rd March 2025 has been brought to the notice of the court. Stop.
The order
Let
of
the
the
writ
third month is
petition
only to file
appear in the list on 8th of April.
My lord.
Returnable, my lord.
Shakti.
Grateful.
Seven and 8, my lord. Identical matters. Lordship may kindly takes your lordship's last order.
I want to do this.
Second last order.
Second last order. No.
I'm appearing for 7 months.
Order dated 25th November 2024.
Oh, that eat cola.
Yes.
My lord.
What happened?
My lord, entire thing is done.
What is
Demarcation
done?
has been done. Entire demarcation has been done. This is
Wetland?
No.
Then?
My lord would find the paragraph starting with now regarding the
Now regarding the schedule, it is pertinent to mention that as far as
Tata-
classified as eat cola
is situated
outside. So it is in your favor.
Yes.
But even then, you go through this, I'll keep it pending.
My lord, only thing, my lord, it doesn't require because if he has to, my lord, his ultimate prayer is for conversion.
No, conversion is a different forum.
This forum can, that's why I say,
Yes.
my lord, kindly see the next two paragraph of the report, my lord, matter can be disposed of. Everything has been in his favor.
Petitioner is yet to
Before-
record this and
Kindly,
the petitioner is eligible for filing application for your land is recorded as?
Itkola.
So it is Itkola? Then where is the requirement of conversion? There is no requirement of conversion also.
No, I am seeking conversion from Itkola
To Bastu. Oh, then it is.
a different forum.
That is different.
Absolutely different. In that case, page 49 may be set aside. It is the
49.
Yes. It is the impugned in this
order.
Yes. Kindly comes to page 49.
This is the impugned here.
Not to entertain any proceeding related to record correction and conversion. Known as
Related to
Chhatra
correction
bill.
and conversion as per such and such. Chhatra bill.
Malad, that is Chhatra bill. This will not affect them because it is
Uttar-
now.
One minute. The Uttar Ramchandrapur jail number is there. Do you fall in any of these?
Uttar Ramchandra.
Uttar Ramchandrapur is a big area.
Yes. So showing this order.
What is this?
Showing this order.
Huh?
Showing this order, they were not entertaining any correction of records.
Doesn't matter. I'll keep this on record.
Yes, clarifies that in respect of this,
Not touching
it can
this.
be done. But my lord,
Please come.
this
It is
my
clarified.
also
Last
submission
paragraph
before your
clarified.
lordship is there.
It's better. I'm passing it over. You go through it.
To be report.
I'm passing it over.
Last
Right?
paragraph is
You
that-
go through it.
Hence, in this regard.
Lest
they
any
apply
problem
for
arises.
conversion.
পরেরটা রাখুন। Next one also 8.
Eight.
8 is what? Itkola or what?
Danga. It is
দেখি report.
Danga to
Malad,
Basti.
next matter, I'm not appealing.
Next
Uh,
matter,
some-
Mr.
some
This
other,
was,
You were there in Shekhar Goswami.
I am
Who is
only for Chekhar.
8 Pappu? Who is there?
Mr. Chondicharan Dey is appearing. Kindly takes your lordship's last order.
No, last order will not do. A report was to be filed. He has got the report. Is it the
Next
same?
matter,
The character of the land is the same. Get hold of Mr. Dey.
Same issue, my lord. Seven.
It is not the issue. It is not the issue. It is the demarcation, whether it falls within the wetland area or not. If it doesn't fall,
No, my lord.
it's all right.
Lordship, kindly clarify this, my lord, that
Let the instruction come. Get hold of Mr. Dey.
instruction has already submitted, my lord. It's my matter, my lord. As far as 9 item number is concerned.
আচ্ছা দেখি 9 নম্বরটা কি আছে?
Kindly takes up, my
Has
lord.
already-
Kindly, my lord, I'll be placing, my lord,
I am
Which
for-
one?
8.
8, call Mr. Dey once. Just giving a phone call and come back. And this 7 is passed over. Just see it and come back.
Yes.
Yours is 9.
9.
Let me see. Who is your other side?
নামটা কি জানো মেয়েটার?
Sabnam De Burman. Where is she? Call.
My lord, another matter arising out of the same original application, which is 1260. My lord, there, the issue that, my lord, we are not being able to, my lord, convince the tribunal that since we have preferred the writ petition, my lord, the tribunal should stay its hands and should not take. My lord, there the issue is with regard to the order. One of the first round litigation order is also also annexed here. Issue is with regard to the jurisdiction of the National Green Tribunal to entertain this application. Now, my lord, in the first round of litigation, we had approached this honorable court. The judgment of Honorable Justice Shubhashachi Bhattacharya is also annexed here. His lordship was pleased to hold and come to the specific conclusion that yes, if this issue is not, this will NGT until there is a notification cannot take up these issues. But, my lord, since, my lord, this is a tribunal and the senior members are there, he had remanded the matter back to the tribunal for last chance so that the tribunal itself passes an order adjudicating its issue. But, my lord, the tribunal has passed an order relying on a totally different matter and has said that no, we have jurisdiction. That is challenged before your lordship. Item number 1.
So let it remain. That is not, there is no urgency.
Urgency because of this fact, my lord, this in demarcation is going on. And, my lord,
Let
what
the
they-
demarcation go on. You are not troubled with the demarcation. You were troubled because your land was not being allowed to be converted.
in all the cases, this particular memo has been relied upon. And, my lord,
Doesn't matter. Each and every
we
case
are
will
not
pass
being able
separate
to do
orders.
anything in that matter, my lord.
We'll pass separate orders. 9.
Other side is here, madam.
Where is your other side? 9.
এসে তো কোথায় গেল? Just a moment.
Call 10.
I am for the state respondent.
Petitioner is here or not? Item 10.
I appear for the private respondent.
What happened yesterday? This was not here.
Yes, my lord.
Yesterday you fell
There was a
down.
High Court's cricket tournament, my lord, it was on Sunday. Last evening, my lord, after the X-ray, I found it's fracture, my lord.
Fractured. What were you doing? Bowling or
I was
batting?
batting, my lord, was trying to complete a run. I dived.
Yes. Your mind goes, but your body doesn't permit. This is the difficulty.
My lord,
Yes.
directed will share it to file report. My lord, directed to file the report by the
Madam,
CRT.
Yes, give.
Madam, for the petitioner, lordship.
Yes.
My lord, this is that case, lordship, where I am the auction purchaser
of a property from Central Bank of India
Steps taken
and was in possession of the property. And while enjoying the property lordship, Karur Vaishya comes up and says that there is an order of section 14.
Everything will be clear. Open it.
The prayer in the reputation.
Which portion? Steps taken. The preparation has received additional deputation. Revealed inquiry. Borrower failed to repay the loan. The central bank obtained right from the DM. Take possession. 2020. DM has given right to take possession 2021. CBI central bank sold the property in 2023 and that has been registered. Participating in the auction. During peaceful possession, the petitioner was served with a notice that the Karur Vaishya Bank limited the property and the possession of the central bank was there, then Karur Vaishya comes in. And some discrepancies in the title deed. Different signatures. This is the bond.
And as per number 11, my lord, did the fraud, my lord. Private husband 11. And DM also took hearing, my lord, on, my lord, they did not appear, my lord.
Completion of the inspection by the bank. A detailed report has been submitted to the DM for taking necessary action against both central bank and the Karur Vaishya.
Karur was non-dependent on the last date of hearing before the district magistrate, my lord.
The letter has been received from the office of the district magistrate. It has been called the bank authorities are requested to happen and the chamber of the other. Karur Vaishya did not appear.
Yes, my lord.
So there has been some type of fraud that has been played.
My lord, from the first instance, the private respondent took a loan of rupees 70 lakhs from Central Bank of India. I purchased the property.
You circulate this report.
Subsequently, lordship.
What is happening because the bank is knowing.
Subsequently, lordship, from Karur Vaishya, he takes 1 crore. He is very close acquaintance in another writ petition before lordship.
Very well, but then you purchased the property.
I purchased the property from Central Bank of India. I have paid 53 lakhs to Central Bank of India and stamp duty registration charge another 2 lakhs.
And you are getting the property.
I have got the property.
Yes.
I am possessing the property. I am enjoying the property.
Grievance.
My grievance is a notice has been affixed by Karur Vaishya stating that an order has been passed. I have to leave the property. I have to vacate the property. That is my grievance. Lordship. And when I approach before the district magistrate, ADM and the offices concerned, the Surfacey, they are not cooperating me. They are not making available any record to inspect, to peruse what is going on. They are only helping the perpetrators to proceed with this kind of fraud practices. And number of orders have been granted by the Surfacey.
And your cases, section 14 was allowed in your favor.
Yes, my 14 was allowed, my lord. But I have given a loan against this property. Now, my lord, even if I assume the case of my learned friend to be correct, whether this is the correct forum to agitate this issue.
Yes.
And plus the fact, section 17 of the Surfacey Act, it starts with the expression, my lord, section 17, any person.
Yes.
Any person also includes auction purchaser, their judgments, my lord.
Yes.
Now, whether they should have gone to DRT or this court. And second, I am a private bank, whether this writ is maintainable.
Please come.
Because if my lord takes the press, it's really against, my lord, the Surfacey steps taken by the private bank, my lord. These issues have to be decided.
The petitioner is petitioner participated in an auction and purchased the subject property from the Central Bank of India. Stop. A sale deed was prepared and registered. Stop. The petitioner is in possession of the subject property.
Your client is absolutely innocent.
Stop. The Karur Vaishya Bank has affixed a notice for taking possession of the subject property. Stop. The said notice has been affixed after the bank was successful in obtaining an order from the district magistrate under section 14 of the Surfacey Act. Stop. Paragraph. A report has been filed by the Inspector of Police within bracket Inquiry Officer Anti-Cheating and Fraud Cell, CID West Bengal, signed on 3rd of March 2025, wherefrom it appears that the matter is being inquired into. Stop. The district magistrate has called for a hearing of the parties. Stop. On 22nd February 2025, hearing was fixed by the district magistrate and collector, but the Karur Vaishya Bank did not appear. Stop. Paragraph. As the relief has been sought for against a private bank, that is the Karur Vaishya Bank, the writ petition is held to be not maintainable. Stop. The parties will, however, be at liberty to approach the competent forum for relief. Stop. The inquiry that is continuing shall be concluded in accordance with law. Disposed.
My lord, only one indulgence. My lord, my relief was the acts conducted by the authorities, public authorities on
Who is the public authority?
Lordship, the district magistrate and its office.
Yes.
Who has inspected, being satisfied by the fraud practice conducted by the Karur Vaishya Bank.
Now, you have claimed relief against the bank because the bank has affixed that notice.
Lordship.
Isn't it?
Lordship, only
you go before the tribunal that is open
Lordship,
to you, and the inquiry will continue.
Lordship, keeping into mind consideration, Lordship, the notice which has been affixed, which is an outcome of a fraud practice by acting fraud by the Karur Vaishya Bank and affixing in my property, that should be turned down, Lordship. That is my humble submission, Lordship. That should be interfered with.
The DM,
Lordship.
order passed by the DM, is to be executed by the DM by appointing an executive officer over there.
Lordship.
How will the DM execute the order when it is pending consideration? It cannot be executed.
Lordship, some indication, Lordship.
Nothing of
considering the plight of the petitioner, Lordship. Yes.
To happen.
Lordship, some indication, Lordship. Till appropriate orders have been obtained, Lordship. Some protection, Lordship.
When I am dismissing the writ petition by holding it to be not maintainable, and at the same time I'm passing orders,
with a liberty,
immediately
Lordship,
the bank will go up in appeal and you'll lose everything.
With a liberty, Lordship, to
move
before the appropriate authority,
Yes.
and delay be condoned, Lordship. Delay.
No. Where is the delay? The bank has affixed the notice recently.
Lordship, I came up before your Lordship.
Delayed. No, this you have got. Check out the law.
I'm grateful, Lordship. I'm
Yes,
grateful.
11.
Item number 9 मला अलग से दीजिए यार.
1 minute.
Lordship, a copy of the report be handed over. Lordship.
Yes.
Copy of the kindly records, Lordship. Only one liner. Otherwise, I won't be of no harm.
Call him.
Hey,
A report.
After making just
Yes, make a photocopy and give it. In case it is not given,
Lordship, kindly records.
in case it is not given, mention.
Within half an hour.
Copy of the report I am for the private respondent.
Which private respondent?
The fraudster, Lordship. The fraudster.
Investigation is going on,
The fraudster.
investigation.
Yes,
The fraudster.
participate.
We have no locus to ask for a report.
अच्छा act a line लिखे नहीं तो let the report filed in court today be circulated to the respective councils.
I'm good.
11.
And I for the petitioner in this matter.
Yes.
Pursuant to your lordship's last order, my lord, they have communicated the name of the assistant engineer in deleting to plot number only 5/2 feeder road. But other two plots, they
that
have
was
not
the-
intimated to a petitioner.
That was the order, my lord.
Kindly come to the RTI
That
application,
was
my
the
lord,
order.
made by the petitioner, my lord, that is page 18.
That was the last order, my lord, to indicate.
Yes, 50, 5/2.
5/2 only has been communicated, my lord.
What
Other
else do
two
you
plots-
want?
Out of other two plots, 22, plot number 22 and plot
Where
number
is
28.
your query?
Yes. I have mentioned, my lord, kindly come to page 16. The RTI
You could have
application-
told the last day because the order was only in respect of 5/2.
No, RTA application, my lord, they have communicated
Listen.
only Kamal Dotto, the name of the assistant engineer, only in relating to plot number 5/2 road, feeder road, my lord. Other two,
When order was passed on the last day, you were present.
yes,
Why
yes,
did
yes,
you
yes.
not tell? I
Lord,
could
I
have
have,
in
I have said, Lord,
what you've said. It is only 5/2 that you inquired.
according to Lord RTA application, there are two plots, other two plots, my lord, that is number 22 feeder road and the other is 28 feeder road. There are three plots of land. But the assistant engineer, only Tamal Dotto, has sanctioned the building only in relating to 5/2, according to him, 5/2 road. But other the two plots, the sanctioned plan, who have granted this plan, I do not know. That was my plan, my lord, in the writ petition.
In one go, you could have collected all the information.
But it,
Please come. The learned advocate for the municipality has intimated the petitioner the name of the assistant engineer who recommended sanction in respect of plot number 5/2 feeder road. Stop. Similar information. No, not similar information. The learned advocate is also requested to pass on the information in respect of query numbers 3 and 4 of the RTI application annexed at pages 16 and 17 of the writ petition.
yes.
By by 13th of March, list on 18th of March.
I'm grateful to you.
I appear for the petition.
Yes.
Well, my lord, for the State
May I
Bank matter.
files the supplementary affidavit regarding subsequent development in respect of that?
My lord, one humble.
Can you see your lordship?
May I make
Interim order? I have annexed in the
one humble submission, my lord. My lord, we have filed one appeal, my lord.
All right.
My lord, because
Against
it is a new-
27th
27th,
January.
It is a new branch of banking, my lord, internet banking. And the laws connected to this branch of is also new, my lord. So the law may be settled because every order, my lord, because various high courts are passing very contradictory orders are there also. Divergent views are there, my lord. So this law is required to be settled, my lord.
What is the direction
My lord, can you see?
My lord.
against
It is in respect of
salaried
that
person?
bank fraud case, petitioner is
the
my lord,
existing bank
teacher of a
account.
madrasa.
Right.
Your lordship directed to
It's totally a
reopen
new branch
another
of
bank
banking.
account and to get my salary
That
from that
has
account.
not been opened.
They have done.
They have opened.
It is done.
So you are getting the salary.
Salary from another account.
Yes. So what is
Now-
the challenge?
My lord, because this direction not to deduct EMI, because our contention was that he has obtained this loan, or he was callous, he was not very much mindful, he obtained this loan, and it was due to his callousness he got this loan.
All right.
So if he has done it by it is his negligence, so he cannot take advantage of that his negligence. That was our contention.
So, but then will you not find out whether it was the negligence of the petitioner or the bank is not acting accordingly?
Police was investigating. Police
I have
was
got the
investigating.
information. It is some of the bank officials very much involved.
No.
Manager involved. Why?
I do not know.
It is
From where
no,
from my
I have
friend is
got the
coming.
information. I am telling.
I do not know
Because the
from where he has
petitioner being the
said this.
victim are the my lord, always soft target,
My lord.
not the beneficiaries here. Now bank has been loan has been created on.
I have followed. Now you are getting the salary, so there is no immediate urgency.
No, my lord, there are some problems.
What is the problem?
Even then, my lord, kindly come to paragraph 8 and 10. I am of my supplementary affidavit. Three problems I am facing.
Yes.
One, my lord, the 3 EMI has been deducted.
Huh.
It is to be refunded
Yes.
to my original bank account. Second is till date the bank is issuing SMS for making payment of that loan.
EMI.
EMI.
Very well. The EMI issue is before the division bench. You sort it out over there.
And my lord, third thing, my lord, kindly come to paragraph 8. And third, this loan account should be closed
Yes.
in future. Otherwise, my lord, I shall not get any loan.
Yes, yes. This I followed. When is the appeal likely to be
My
taken
lord,
up?
we have mentioned it today before the Honorable
All
Division
right.
bench. In the next week, the Honorable Division has said
All
that
right.
next week taken up.
Yes. What is your submission? State.
This is the present report
Yes.
where from the report it's found that one juvenile Rajesh Kumar is it around 14 years already under custody of the Devgarh police case, and apprehension is that he is also connected in the present case also, and already
You furnish all this information before the honorable division bench. Let us see you also. It will help you.
And my lord, one thing, my lord, I
Case number is here.
yes, my lord, I have learned since he is saying so. The victims are always the soft target in this type of case. Now, my lord, I cannot resist myself whether the bank official can be punished or not. To that extent, my lord, kindly think about this.
If their involvement
Because-
is found, my lord,
yes,
they will be
because
punished.
the bank authority my lord, generated 21st of every month, and he is deducting from first day of month. Kindly see the nature of the calculation. The moment salary is my lord, entering in my account, deducting,
Automatic deduction.
automatic, and although it has been my lord, created on 21st of every month, how that 20 days? Unless the bank my lord, manager is my lord, involved, my lord, I have got the information from my client.
Very
He is
well.
there. Can you
Please.
decide that issue?
Very well, please.
And that type of public money
Report
up to the
filed by
Supreme
the
Court
inspector in
cannot
charge,
be diluted in that fashion.
Cybercrime Police Station, Barashat
ঠিক আছে,
Police
দেখি
District. Signed on 2nd March 2025 is written with the records. Let copy be circulated.
My lord.
Got it?
Yes, sir.
Tale let na. Copy of it has been circulated in court today. ঠিক আছে? It has been brought to the notice of the court by the learned advocate representing the State Bank of India that an appeal has been carried from the order dated 27th January 2025, and the appeal is likely to be taken up by the Honorable Division Bench shortly. Stuff next. In view of such submission, the writ petition stands adjourned till 1st April.
Grateful. But kindly decide that issue also.
Acha, supplementary affidavit
Appeal court. If,
on behalf of the petitioner filed in court is taken on record. It is better you get it decided over there.
all right. No, I
That
shall-
will
I
be
shall- I
that
shall-
will be
I shall.
helpful
There should
for
be end of
this
it.
bench
What
also.
happened,
Expense
my lord,
also.
various divergent views are coming
Ah.
from different high courts,
Yes,
my lord.
yes.
Different high court.
So
Bala
this is
Supreme
a very
Court,
new branch
3rd
of
of January
banking.
already
This is a very
settled the
new
issue.
branch of banking.
Let us see. Yes. So, very soft target are the victims, not beneficiaries, who by virtue of that fraud are the beneficiaries.
The bank officials have to move faster than these fraudsters.
Yes.
If they move in the same line, you'll not be able to curb it. You have to think fast.
Grateful.
Yes, next 13.
Anyone can be the victim of this
Yes,
type of
anyone can.
Respondents, yes.
No, copy may be circulated, that report.
It has been,
No, I have not got the police.
only one copy is left. Already I served the copy to bank respondent.
make a photocopy,
Yes.
click a photo, whatever, do it.
Grateful dealers.
Railway department adopted a policy.
Railway,
Railway. My lord, it is our written instruction issued by Railway Authority, my lord.
My lord, that a tender process, they will supply as a site. They will supply as a condemned rail coach. Now we have to make arrangement. They will my lord, transfer the same to that particular site. There we have to get it modified, and there we will my lord, start or run my lord, as restaurant.
all right.
Now I participate the same page 5, my lord, page 19 P1. That's the contract agreement with the authority. Now it's for 5 years. The contract start date is 23rd of November 2024. Now, what happened here, my lord? I deposited the fees as I was asked to do. They supplied me the site. And they said they will hand over a condemned, my lord, coach for me. We have made all facilities to bring the same, but we cannot bring unless that is supplied by them. Repeated occasions we sent letter. No positive step. In the meantime, the site which was, my lord, proposed for us by that side, my lord, a public urinal or public toilet that has been established at the instance of the railways. Now, hardly there would be a person, my lord, who will purchase anything from us. We intimated the same. Now, for your laches, your fault, I am not in a position to run this anymore. So please refund the money which you have.
Run means you did not get the coach. Then how could?
Yes. So if they allow, if they supply, even then we cannot. Because the site that is fixed. Two things, the site and then the coach. Site that was, my lord, allotted to us. Coach that was never. Now, even if today, my lord, they hand over that coach to us.
And this public urinal was constructed afterwards.
Yes. I need, my lord, two things. Please refund my money which I have deposited to you pursuant to this, as well as my earnest money. The other cost which I suffered, I am not asking for the same. My payment at page 22.
See, the instruction from the railway is that the condemned coach was provided to you in October 24, and it is lying in the sick line.
Right.
It has been intimated to you to visit the coach.
More kindly.
You are required to pay for shifting the coach, which you did not.
Yes.
Yes, sir. Page 70 minus page 79.
Kindly go through the same, or then I shall.
Denied the responsibility to shift.
My lord, kindly see page 8 of instruction, my lord.
Page
8.
Who are you?
Respondent.
Both we are.
No, both will not address. Only one will address.
If my lord, kindly see, my lord, kindly peruse, my lord, page 79, my lord. Page 79, annexure P11, my lord.
Yes.
My lord, may I go through? May I go through? My
Yes, yes.
lord? But in reference to the above, my lord, it is a letter from railway authority, by the railway authority to the respondent, to the petitioner, my lord. In reference to the above cited letter, this is to inform you that nominated location for PCR was handed over to you on 7/9/24, and track fittings work was completed on nominated location within 1 week after handover location. And I have informed you that railway authority has nominated the condemned coach being number just my lord, which has been lying at Shalimar sick line. I have physically visited the coach of sick line at Shalimar with you and your manager Pushpender and Nagender, along with shifting agency several times. You have not confirmed the amount of shifting along with interior seat and other cutting expenditure by first agency. There, I am communicating.
Where is your communication to the authority regarding the public urinal and all these things?
Or kindly come to page 76.
My lord, that is the not
76. Yes.
according to
Let
their
me.
my lord,
But
according
76 is the contract agreement for the urinal. Kindly have a look. What is the date? 22nd of October 2024. Now, my lord, kindly have a look to the handover of site. That is at page, my lord, 26. Page 26, the 7th of.
Did you intimate the authority that?
Yes.
Because where is the communication?
P10,
Your
madam.
presentation?
P10, page 76.
Page 76.
78. Madam, if your lordships kindly allow me, my lord.
There is no translated copy.
My learned friend, my junior can read it out.
No, it's all right. But then any response to this?
The response is page 79, which has been.
Oh, page 79 is the response.
Yes, now
No,
page
there
8.
is nothing with regard to the urinal mentioned
Yes,
over
now
here.
page 80, my lord, we have said everything again.
80.
Yes. Well, two things kindly, my lord, visualize two things. Kindly come 1 second, page 79.
Yes.
Page 79, that's their letter dated 25th of November 2024. The response letter, they said 18th of October 2024, they have fixed a coach. 18th of October. Now, site that was handed over to me in the month of September. Now, kindly come to page 76.
Yes.
22nd of October 2024. Now, 18th October, according to them, they have fixed a coach for me. And 22nd, they have, my lord, allotted someone, the site beside me, to construct a urinal. How could this be, my lord, run together, side by side?
Where is this brought to the notice of the authority?
Page 78 and page 80. No, my lord. What is the 78?
The portion where you have mentioned as regards the urinal, where is it? Which portion?
From top 5th line at page 78.
Page 78. Yes. Listen, your instruction also does not mention anything about the urinal.
Yeah, my lord, the main issue is not the urinal. Main issue was shifting of the railway coach, my lord. But shifting of the railway coach, and we in that.
But page 78,
we
second
have
paragraph.
already given an estimation. My lord, we have already given an estimation of 2,10,000 and
for shifting.
For shifting, but
Yes.
but they did not agree to pay the same in advance. If suppose they quit from their business, then railway authority will be in peril. Railway authority also will be in peril, my lord.
No, tell me, is the railway seriously thinking of constructing a urinal by the side of this?
That has already been constructed. That's my instruction.
That is not the issue. They have not given the money, the latter money within time. Then it may be happened. Then it may be allotted.
What it may be? Has it been cancelled? The petitioner's offer has been cancelled?
No, madam.
Then he still has, the offer is still open, isn't it?
He have accepted.
So if he intends to set up that coach over there by spending 2 lakh of rupees, what is the use? By the side of the urinal, it will not function, it will not run, nobody will go over there.
But may I read out the second paragraph of page 78?
Have you followed?
Yes, madam.
What? Where is that mentioned in your instruction?
My lord, actually, it is written in Hindi, my lord.
And so your authority did not look into it?
No, already they have looked.
Where is it mentioned in your instruction?
But they have not specifically focus on the on it.
Well, may I read
specifically
it?
focus on it, my lord.
The second paragraph at page 78.
If my lord kindly peruse the synopsis portion, my lord.
No, I'll not see the synopsis. You have to see what the grievance of the petitioner is and then you answer. You answer something else, the petitioner has some other grievance. Yes.
अतः श्रीमान से ये निवेदन है
अतः
श्रीमान से ये निवेदन है जिस स्थान पर रेल कोच का लोकेशन दिया गया ठीक उसी से सटाकर डीलक्स बाथरूम भी बनाने का टेंडर करा दिया गया है। इसलिए जिस स्थान पर टॉयलेट रहेगा उस स्थान से खाना बनाकर पैसेंजर को सर्व करना कहीं से भी सही नहीं होगा। इसलिए डीलक्स टॉयलेट को देखते हुए दूसरी जगह रेल कोच की शिफ्ट किया जाए जिससे पैसेंजर आकर जलपान करने से कई
प्लीज कम।
Further instructions.
The petitioner was offered a contract for setting up of a food stall at a specified location fixed by the railway authority. Stop. Grievance of the petitioner is that just by the side of the site where the food stall is to be set up, a public urinal has been permitted to be constructed by the railway. Stop. The petitioner apprehends that no customer will visit a food stall by the side of a public urinal. Stop. The petitioner will lose financially if the stall is set up at the said location. Paragraph. A prayer was made by the petitioner for permitting him to shift the railway stall, not railway, this stall, the site of the stall. Stop. There is no response from the end of the railways with regard to the shifting of the site of the stall. Stop. According to the railways, the petitioner was requested to shift the railway coach at the proper place. Now, at the specified location.
This is a rail track that was arranged by us. That we have already stated.
Stop. The petitioner has not shifted the coach only because of the construction of the public urinal. Stop. Paragraph.
Or public toilet, that will be better.
It's a public toilet. The instruction forwarded by the railway also does not mention anything with regard to the request made by the petitioner for shifting the food stall to be set up by the petitioner. Are you agreeable if you are allowed to shift the stall?
But they have to then place a site, my lord.
Yes.
Whether that provision is there, whether they have that site at present.
Achha. The petitioner prays that in the event the petitioner is not being.
It's not a stall, my lord, it's a restaurant. Can you use that rail coach restaurant?
Rail coach restaurant. যেখানে যেখানে ফুড স্টল বলেছি না ফুড স্টল সেটা হবে
can be accommodated anywhere.
রেল কোচ রেস্টুরেন্ট।
Probably there is one in our Shialdah station at present.
What is your prayer for refund of the money?
No,
there are other prayers also, not to take coercive steps. Not to take coercive steps.
Because if I fail to pay next, because there is, my lord, a quarterly payment is there. So, my lord, they may take action against me. That's, my lord, I have prayed everything. My prayer at page, my lord, 15.
Achha. Prayer, page 15, you say is refund of the license fees.
Yes.
Permitted to run the restaurant at a different site. Na ki bollam? To run the business at different site. Then the license fee, comma, security money, comma, track laying cost.
Track laying cost that I am not pressing at that moment, my lord. If they are agreeable, only my security money and the payment, the fees which I have paid. Let them return it back, or I shall go.
Security money and the license fees paid by him be refunded. Stop paragraph.
Probably they
As it
don't have any other
appears-
alternative site.
As it appears that the request made by the petitioner is pending consideration at the end of the authority. Accordingly, the instant writ petition is disposed of
I kindly don't dispose it to my
by
lord. I have to
directing
suffer a lot, my lord. Kindly fix any date, let them come before lordship with a necessary response, my
it
lord.
will not help.
But
Because
otherwise-
whatever is the
Otherwise, they
finding
may come with
opinion-
the proposal before lordship. Yes, they are agreeable, my lord, I will go. Otherwise, my lord, they will keep it pending. I have the experience, the bitter experience, my lord. Every time we are facing this. For one incident, we have to come before lordship for 2 or 3 writ petitions. Kindly make it returnable after.
Where is this place?
It's
Where
Salimar.
Howrah, Shalimar. Who will be the authority? Respondent number 5, Director Tourism and Catering. Or this
The commercial manager.
Assistant Commercial Manager.
Hello.
Want to have some water? Have some water. Respondent number 7 করে দিন। Senior divisional. Who will be the authority? The senior divisional officer or the assistant commercial manager?
Or the senior divisional commercial
Achha,
manager.
respondent number
Respondent number 6.
Respondent number 6. Is directed to consider the prayer of the petitioner. Petitioner, after giving an opportunity of hearing to the petitioner and after causing a physical site inspection to ascertain as to whether the apprehension of the petitioner is correct or not. Released on 21st of April.
Great, madam. Great.
Report retained with the records. Service is also taken on record.
Great.
Mr. Chundicharan Dey is here.
Yes, what happened?
7, 8, and 9, my lord.
My lord, I'm appearing for 9.
Number
7.
Kindly takes up, my lord, the brief, the report that they have given. Kindly takes up the brief of item number 8, where Mr. Chundicharan Dey is a similar report. It is that is, my lord, easier, my lord.
How can it be similar? Because this
Similar,
report is
similar.
being filed today.
Kindly bears with me for one moment. I will be distinguishing also, my lord.
Nikki,
Kindly takes up that, my lord.
filed
Pappu Jaswal, because this was the matter where all the orders were being passed.
Yes.
Yes. Kindly seize, my lord, this report. Now regarding, Lordship is there. Now regarding the schedule of land involved in the particular writ, it is pertinent to mention that as per the data acquired from the demarcation process itself, the suit such and such clarifies as Danga is situated outside the demarcated area. Supports me. It is also important to mention that as per the computerized LR plot information of the scheduled land, it is evident that currently such and such areas over the said plot is recorded in favor of the instant writ petitioner. Is also, so it is admitted. Hence, he is eligible to apply for conversion over this quantum land. And if the petitioner applies for conversion over the suit land, the same may be disposed of by competent authority as per existing provisions of law, and leave may kindly be granted so that disposal of the same may be done after obtaining the final order passed in the National Green Tribunal, as the bar on conversion of plots in the said Moza was imposed in compliance with the order dated 22nd March 2023 in this. This is totally erroneous because this bar kindly comes to page 49. This is the subject matter of challenge. This is totally misconceived since there was no order of the tribunal for imposing this bar. Now kindly comes to page 49.
22nd of March 2023.
Is the order that they are quoting. Kindly
Yes.
comes to page 49. I'll be taking your lordships to 22nd March 2023. This is the bar which they are talking about.
Yes.
In compliance with the order dated 22nd 3/2023.
Show me the order.
Now, kindly comes to page 36.
Yes.
Paragraph 14. Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members. Done. The committee shall visit the Chatra bill and inspect the site and submit its report with regard to the encroachment alleged to have been made upon the said water body, and it shall suggest remedial measures of restoration of the said water body to its original pristine form, as well as remedial measures to ensure that there is no further encroachment into the water body. Lordship will not find anything which, my lord, says that you have to impose a bar. So this concept that it is being done is totally. Now, my lord, kindly cease challenging these orders. The first round of writ petition was moved.
Item number.
Where, my lord, only
Item number.
one.
Please, no further. 7. 7. A report has been filed by the Additional District Magistrate and District Land and Land Reforms Officer Malda, wherein it has been clearly mentioned that the land of the petitioner is classified as Itkhola and the and the same is outside the demarcated area of the water body. Dash C লিখবেন ছাত্র bill. Stop. The demarcation of the boundary of the water body, Chhatro bill, is complete. Stop. The authority does not have, the authority has mentioned that the petitioner is eligible for filing application for conversion. Stop. Paragraph. The the note mentioned in the report of the ADM is that the conversion of the plots will be considered only after order is passed by the Honorable Tribunal in OA number 30/2023/EZ. Stop. Paragraph. Reference has been made to the order dated 22nd March 2023, passed by the Honorable Tribunal in the original application. Stop. I have perused the order dated 22nd March 2023. Stop. The same relates to the illegal filling up of a water body. Filling up of the above mentioned water body. Stop. As the authorities have come to a concluded opinion that the subject land of which the petitioner seeks conversion does not fall within the demarcated portion of the water body, accordingly, there is no requirement of obtaining any further order from the tribunal for conversion of the classification of the subject land from Itkhola to Bastu. Stop. It will be open for the petitioner to apply for conversion, and the authorities shall take necessary steps to consider the same in accordance
So
with
this
law.
is, your lordship is passing in this first matter.
Stable, my lord, only
Shekhar Goswami. Shekhar Goswami.
Shekhar Goswami, my lord, it will for recording of the name and for conversion.
my lord, recording of name has to be preceded because my lord would find in the instruction
Yes,
starting
yes.
from.
Should be recording
my
of
lord
name.
has not
Yes.
recorded that part. It has
No,
to be
because
recorded.
name I did not notice. I only noticed the conversion of classification.
My lord,
Name I
name
did not
featured in the revenue
That
record.
is in Pappu
And
That
Jaswal.
is that is
That is
Nikati.
why I
the
took Pappu Jaswal.
petitioner has also applied for mutation of his name in the subject plot. Stop.
I'm grateful, ma'am. That is
The authority shall consider the prayer of the petitioner in accordance with law. Disposed.
But this is item number কত discussed?
7.
8.
8 is, my lord,
Same
Pappu
জিনিস
Jaswal.
হবে কিন্তু ওই
Lasted.
মিউটেশনের
Mutation
পোর্শনটা
part.
হবে না, লাস্ট লাইনটা হবে না শুধু, আদারওয়াইজ ইট উইল বি দ্য সেম।
But in the first matter, without being influenced with the pendency of OA, my lord, kindly, my lord.
I have mentioned it is nowhere related.
9 মালা বাগান টু মালা হোটেল
Where is the report of 9?
Similar report.
Let me see the report.
Same report.
সেম রিপোর্ট
Report দিচ্ছে একটা দিন।
সেম এরিয়া মালা
Same.
সেম অনলি মালা বাগান টু হোটেল কনভার্সন
8 and 9 same report.
সুব্রত বাবু, ওখানে সেম বললাম কিন্তু 8টা কিন্তু ইট খোলা নয়, 8টা ছিল ডাঙা। 8 নম্বরটা ডাঙা ছিল। হ্যাঁ, আপনি ওই ইনস্ট্রাকশনে দেখে নেবেন, এখানে লেখা আছে প্রথম একটা ইট খোলা ছিল, তারপর একটা ডাঙা, এটাও ডাঙা। আর এটাতেও নেম মিউটেশন ইজ নট রিকোয়ার্ড,
No.
only classification is
Yes, sir.
required to be changed. তাহলে এখানেও
বাগান তো
সেম
হোটেল।
হবে। Where is 9's report?
9 রিপোর্ট তো তোমার
That এটা তো পাপ্পু জয়সওয়াল রিপোর্ট। 9 দেবেশ সাহা's report. Where is দেবেশ সাহা's report?
এটা মনে হয়।
কোথায়?
It is already filed on the last occasion.
অলরেডি ফাইল বানা দেয়া বিফোর দি কোর্ট
How can it be filed before the court on the last occasion? Because the demarcation was not there at that point of time.
দ্যাট ইজ
Demarcation has come later on. এটা হবে না।
But it has been rejected from conversion to Bagan
Why?
to hotel because on the
Because of
earlier
pendency of-
occasion for conversion of said plot from Bagan to hotel, but the said application conversion was rejected
Don't read out. Tell me why it has been rejected.
because it's in purview of Chhatra bill be ascertained.
সেম
Where is the demarcation?
Demarcation, so it is under process.
Who said it is complete? Other reports are there.
Pappu Jaiswal, but not
Demarcation cannot be done only in case of Pappu. It
Yes,
has to be done in respect of the whole Chhatra
Chhatra
bill.
bill.
then it is similar.
How can it be similar?
Then I have to take instruction particularly.
Why did you not take it? There was specific direction.
দিস ইজ এ ফ্রেশ রিপোর্ট বানা আর দ্যাট রিপোর্ট ইজ প্রিভিয়াসলি বানা
This is the old report.
কাইন্ডলি ডিসপোজ অফ দি সিমিলার মালা সিমিলার
No, it cannot be done till I see a report from the authority.
বিকজ এরিয়া ইজ
Sir,
সেম মালা
লিখুন তো।
ওটা ইজ সেম মালা
The report
মানে কোয়াইট ন্যাচারালি মালা
by the DL and LRO is required to be placed before this court. Stop. Released on next Tuesday.
Fine.
Let the report be placed before this court. 11 তারিখ। Yes, call the next matter. এটা ফেরত দিয়ে দিন।
Diplobladge.
পাপ্পুর বোধহয় অলরেডি আছে, এটা দরকার নেই, পাপ্পু ফেরত দিয়ে দিন। দেবেশ স্যার এটা ফেরত দিয়ে দিন, এই ফাইলটা রেখে দিন।
লাগবে কি
No.
Madam, for the petition in this 14, my lord. My lord, this was filed against the inaction on the part of the authorities under section 14. The order was passed by the DM, but it was not carried into execution. That was the grievance of.
Why?
My lord, they were not providing the appropriate person,
Executive
engaging the
officer.
appropriate person for carrying out the order, but that has been done. Possession has been handed over on 22nd of January.
My lord, this
Then
is
this
the
has
DM
become
report.
infructuous. Please come.
My lord, I'm filing the DM
Yes.
My lord, may kindly
The
note that
advocate for the petitioner submits that the Grievance of the petitioner has already been redressed by the district magistrate. In view of the above, there is no requirement of proceeding with the writ petition any further. Stop. The same stands disposed of. Report by the DM, North 24 Parganas, dated 28th of February 2025, be written with the records.
My lord, I'm for the petition. My lord, on the last occasion, my lord, your lordship has sought for certain clarification with regard to a statement whether, my lord, a mortgage deed has been executed or not. My lord, and you pursuant to your lordship direction, my lord, I am also filing the, my lord, the affidavit also, my lord. Yes, my lord, it appears, my lord, there is a mortgage deed. There is a miscommunication, my lord, between the petitioner and the client. My lord. That's why, my lord, this confusion has erupted. Moreover, my lord, no copy of the mortgage deed has been submitted, forwarded to the petitioner. So, my lord, he is a class 7, possibly, my lord, he is not aware of the legal nitty-gritty. So, that's why, my lord, he thought the declaration is the mortgage deed. But no copy, subsequent, my lord, the deed that has been executed, no copy.
What will happen to the false affidavit that has been
My lord,
sworn?
that was absolutely, my lord, I tender, my lord, the petitioner tender unconditional apology, my lord. That was a mistake in interpreting and understanding the true purport and content of both the document. Well, that is the mistake, genuine mistake, because no copy has been served upon him. But there was a declaration has been made, but declaration is there. But declaration exists. My lord, this subsequent thereto, my lord, the another deed, my lord, that was executed, my lord, that copy was not forwarded to him. But only the deed with the bank, my lord, he was under the impression, my lord, that that is the first deed. So that's why, my lord, I have, my lord, the instruction was given to the advocate that only a declaration has been created. My lord, he is not aware the legal nitty. There was no intention, my lord, to, my lord, make any false averment. It has, my lord, occurred, my lord, due to, my lord, reason beyond control, my lord. That's why, my lord, in understanding the
Lordship, may I subject to being an officer of the court. Your Lordship, at the outset, it would be evident from the record that I'm not against the petitioner, but being an officer of the court, I want to submit.
On behalf of the petitioner is taken on record.
Lordship, it would be.
The petitioner is aggrieved by the steps taken by the bank under the Surfacey Act. Stop. It will be open for the petitioner to approach the competent forum for remedy. The petition dismissed.
Lordship,
but only one thing,
I was
the
only
limitation party is concerned, my lord,
cannot be.
My lord, because since
False statement on oath, thereafter tender apologize, thereafter seeking liberty.
Liberty
cannot be. You cannot have both the world at the same time.
That's great.
Lordship, I am for the petition.
হবে না Yes.
I'm for the respondent bank, respondent number 5.
My lord, this is my affidavit, sir. My lord, I served all the respondents.
State is here.
I don't know, my lord. They have
Last even the state was not.
DM has accepted.
Did you serve the GP's office?
DM is the.
Did you serve the GP's office? Why?
I'm telling frankly.
There is no frankly required. Serve the GP's office if you want an order.
Tomorrow.
The writ petition is not maintainable.
Force.
It's not maintainable, my lord. It's against the private bank challenging the order under section 14, my lord. On the last occasion, sir, just on the, I know, sir, but I know, sir, I know to make submission on the last occasion when I reached the challenge of maintainability, my learned senior friend.
Petitioner is aggrieved by steps taken by HDFC Bank Limited. Stop.
My lord, kindly see the annexure P1.
The court is of the opinion that the writ petition against HDFC Bank,
my learned fees is not right. My lord, kindly see annexure.
Yes, my lord, kindly
see. আমাকে বলতে দিন।
Sir, বলুন।
My lord, kindly see the page 9, annexure P1.
Yes.
This is the order passed by learned district magistrate, Howrah.
Yes.
I have served.
Yes.
My lord, kindly see.
What do you want?
Without serving any notice upon me, he passed ex parte order.
Yes.
Under 13(2), I am entitled to get a notice, and the DM passed an order, ex parte, in the presence of, in my absence of me. Mala kindly see section 13(2) of the Surfacey Act, where it has been noted that I am entitled to get a notice under section 13(2). They have not served any notice and they passed an ex parte order. I'll be in the street. Well, can you see 13(2)?
Please come. The petitioner is aggrieved by the steps taken by the District Magistrate Howrah under section 14 of the Surfacey Act 2002. Stop. The bank the bank approached the District Magistrate Howrah for necessary relief. Stop. The petitioner submits that the District Magistrate passed an ex parte order without granting any opportunity of hearing to the petitioner. Are you the borrower? Are you the borrower?
I am the borrower.
The petitioner is the borrower of the loan. Stop. Paragraph.
Due to my lord,
Section 17
has been
of
done.
the Surfacey Act provides the necessary relief to the petitioner in case the bank or the financial institution takes any measure to recover the loan. Stop. It will be open for the petitioner to approach the competent forum for the petition stands
Before that,
dismissed.
my lord, they have passed an order. Ex parte, my lord, kindly see.
Right of audience to the borrower under section 14, sir.
My lord, kindly see. Ex parte order has been passed and the property will be auctioned.
17. 17.
Lord, I am for the petitioner.
Yes.
So the last occasion, there was a direction to file report on affidavit by the bank. Well, I must be candid, let's say by 20th, I could not. Yesterday, it has been affirmed. I am filing today. I am also handing over the copies to my learned friend, to the petition. Yes.
Just now, Lord, I have no connection with this bank because I am not the borrower of the property.
The bank will take.
I am the owner of the property. And your lordship will appreciate.
The state is not agreeable to take possession of the subject property to renew the injunction or that is in force. You still have the order of injunction, civil court's injunction, but how can the civil court enter into a issue of surfacey?
One second, your
Cannot.
lordship. The order of injunction was passed against the developer. Bank is not a party over there, but the district magistrate declined to go. One second, the allegation of the petitioner before your lordship is that the promoter has given an undertaking him to give him a flat at the 4th floor, but the property was mortgaged with the bank in the year 2020 and their cause of action arose in the year 2022, that is subsequent to mortgage. Second, the petitioner before your lordship is stating that they are not aware about the surfacey actions of the bank. I have annexed the documents whereby the petitioner, being the owner of the suit building, put a padlock, not allowed the bank to get access to the mortgage property. I have annexed the photographs.
Because I am the owner.
So how they are saying they are not aware?
Whether you are a borrower, whether you are a third party, your remedy is before the tribunal. Why don't you go there?
Yes.
How can the writ court enter into all these things?
All disputed question of fact.
Because this is what the law says.
No, kindly allow me. The property, I am the landlord, I am the owner of the property. That with the private respondent, a development agreement was made. And thereafter I got the possession. So Lordship appreciate very funny thing that
How they will get property mortgage with the bank 2020?
Yes.
That is that flat number of occasion has been transferred in different persons. That is 2018 6 December 2000.
No, whatever. What will the writ court do over here?
Because the notice has been affixed on my wall.
Yes.
This is not the property of the subject matter of the bank.
You go before the tribunal.
I appreciate one.
Lordship,
Nothing to appreciate
I am
here.
for the private respondent, Lordship. Only one thing I have to submit, Lordship. The
Private respondent means, are you the borrower?
I am the developer. The borrower has not been made a party. They are co-owners. There are 3 owners with respect to the property. At least,
kindly allow me to.
Lordship,
go to
at
the
least
report.
may I submit? Lordship,
Yes.
2 things I'll
So,
show to your Lordship. First of all, Lordship, this cannot be.
Please take
আপনি
down.
তো বলেছেন, Lordship.
Go to the report, my lord.
The
Just now
petitioner
may I?
is aggrieved by the steps taken by the bank to recover the loan amount.
we can't do it.
Stop paragraph.
Lordship, only one
It
thing,
will be the petitioner
Lordship,
claims
kindly
that
come to page 32 of their writ
they are
petition.
neither the borrowers. No, neither. No, they are
And
not
disclose
the
all
borrowers,
all
but the owners of the subject property,
Lordship,
which the bank intends to put up for auction.
Put up for auction the particular unit of the entire building.
Acha.
Mortgage to the bank.
কি বললাম?
Not the food. Sorry.
For put up for auction a portion of the subject property which has been mortgaged to the bank. Stop paragraph. It will be open for the petitioner to approach the learned tribunal for relief as provided under the Surfacey Act. Stop. The writ petition cannot be held to be maintainable under the facts and circumstances of the instant case. The same stands dismissed. The report in the form of affidavit filed in court today by the bank is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the
Really,
petitioners.
without going through the report, my lord, your lordship, again, my lord, push me to go to the tribunal, my lord, who will bear the cost?
Call the
Because
next matter.
number of occasion the property has been transferred. Liberty আবার লাগে না, আবার liberty দিয়ে আবার চলে আসে। Tribunal আমি কি?
My lord, I pay for the respondent.
One thing, my lord, one prayer before your lordship.
18, my lord, I beg to appear for the petition.
Yes.
My lord, only one thing, my lord, kindly appreciate one thing. My lord, kindly
My lord,
make a humble one prayer, my lord. Because whether the tribunal have right to entertain my
Yes,
application.
tribunal has right.
Because I am nowhere.
Section 17, everything. Not only right, the tribunal can put you back in possession also.
I'm in possession, no doubt. But
Suppose it is sold and you are dispossessed, tribunal has got enough power to put you back in possession. So, tribunal.
District magistrate order, my lord, is a state authority, and so it is.
Yes.
My lord, I will only praise before your lordships my prayer D.
D?
Yes, my lord,
Against
admittedly,
whom?
my lord, against the bank authority. My lord, admittedly, I am a purchaser of a property even much prior when bank issued loan to the private respondent. By suppressing that fact, private respondent obtained loan. It was not informed to me. What all of us are
Before the tribunal. No, sorry, nothing doing.
Closed.
Nothing
My lord,
doing.
My lord, kindly consider even a new person purchase the property, still I can run my shop over there because
You can, certainly you can run, but get an order from the
my lord,
tribunal.
I can't because my lord, what difficulty I will face? The order passed on 18 January 2024, 14 order pursuant to which padlock was there. Now, my lord, 45 days has passed. I can't challenge that 14 orders before the DRT, my lord. They will come up with the fact that already limitation period has come. Now, my lord, I first get to know on 20 January 2025 when they are about, they went to
Mention this thing before the tribunal.
my lord,
Please come.
my section 5 would not be allowed, my lord, against the bank's order, my lord. My lord, at
The
least, my lord,
petitioner
let
is
me run
aggrieved
the
by
shop,
the
my lord.
steps taken by the bank to recover the loan amount in accordance with the provisions of the
Money shoots
Surfacey
they
Act.
have instituted, then Surfacey proceeding, all suppressed before the DM.
My lord, not suppressed.
Yes, this
the-
suppressed. 2 months.
Well, I'll show the orders.
Petitioner.
Only one has been.
Two has been mentioned. Read.
The writ petition is not entertained at this stage. Stop. It will be open for the petitioner to approach the debts recovery tribunal for necessary relief.
Liberty may kindly be given
Read
to me,
for
then
judge.
my lord, perhaps my section 5 would be allowed. Otherwise, my lord, after
No.
1 year, my lord, nothing would be allowed. Kindly consider the situation, my lord. And it's not that case that I was the party to that proceeding. All of a sudden, my lord, on even I don't have any notice to that effect. My lord, this is affidavit of service.
Yes, service is taken on record. Read for judge.
I'm for the petition.
Yes.
I have said
Well, yesterday it was dismissed for.
Yes, she mentioned
No,
it and I requested
have
to
no difficulty.
intimate you.
I have no difficulty, my lord. Let her move her matter.
I'm
Yes.
challenging the notice dated 23rd September 2024, Lordship.
Under section 13(2), Surfacey Act, Lordship. A person after getting home.
13(2).
Yes, Lordship.
There is 13(3)(a). Why are you here?
13(4) also issued.
13(4) has also been steps taken 13(4). Then why are you here?
After getting 3 loans, the bank authority merged all loans and debited the money randomly, Lordship. And the last occasion on 18th January 2025, they attached the symbolic positions notice, Lordship. That
Yes. First of all, it is ICICI Bank. The writ petition will not be maintainable. Secondly, 13(4) stage is over. Section 17 is open to you. Why you are here? All right, you go before the tribunal. Achha, the petitioner is aggrieved by the steps taken by ICICI Bank Limited to recover the loan amount. Step. The bank being a private entity, the writ petition against the said body will not be maintainable. Stop. Paragraph. It will be open for the petitioner to agitate all points before the debts recovery tribunal.
This is my application. Filing my affidavit service. The petitioner is a senior citizen, 68 years old. Petitioner is a senior citizen, 68 years old. Her husband is 76 years old. The respondent 5 and 6, the elder son and the wife of the elder son are constantly putting pressure on the petitioner to part with her property, and the complaint has been lodged with the police authority. Your Lordship will come to page 22, my complaint at annexure P3.
Yes.
Mananiya Badavu.
Yes. You don't have to read.
Yes. Then again, my Lord, kindly come to page 35, annexure P7. These are my complaints before the police authorities. They are sitting tight over the matter.
What is page 26? You filed another writ petition?
Yes, I filed and order was passed.
Yes.
To maintain peace and tranquility. In spite of that, the private respondents, they are creating trouble for the petitioner and her husband. And as a result, their condition is so deplorable. They are virtually passing their days with anxiety, and they may die any day because of constant pressure put on them by the respondent 5 and 6.
Lordship, we received the complaint in 2023. Lordship, we investigated the matter and filed charge sheets, Lordship, in 2003, Lordship. And we also taken charges against the under section 24-25 of maintenance and welfare of parents and senior citizens, Lordship.
You are taking steps?
Lordship. Police has taken the steps, Lordship.
Yes.
They have charge sheeted, Lordship.
And then
and this is
the same thing is continuing.
That is continuing.
Lordship, this is the matter of 2000. I have the report of 2023, Lordship.
All right, 23 matter. You come up with a fresh report.
Fresh report. Or by learned friend file a fresh application, Lordship, fresh representation. This is a very old representation of 2023, Lordship.
That will be better.
2023 complaints, Lordship.
The petitioner has certain allegations against the private respondents.
Lordship,
numbers 5 and 6. Respondent numbers 5 and 6. Son of Chonchol.
Lordship, one thing, Lordship, we have complied the representation made in 2023. Thereafter, there is no such new complaints before us.
No complaint after the order was passed.
2023, Lordship. 2023 complaint, Lordship.
Where is the complaint?
Annex P27, P7.
P7.
One is 2023.
Page.
35.
35.
It appears from the speed post acknowledgement 10 July 2023, Lordship.
Yes.
From the acknowledgement of the speed post.
Achha.
Thereafter, no complaint.
The private respondents.
On the basis of this complaint, we charge it.
Are the son and daughter-in-law of the petitioner. Stop. It is alleged that The private respondents are pressurizing and threatening the petitioner to transfer the land of the petitioner in their name. Stop. A complaint was lodged before the officer in charge, Batra Police Station, in July 2023. Stop. Allegation is that the level of torture is increasing day by day. Stop. Paragraph. Learned advocate representing the state respondent submits that a charge sheet has been filed in connection with the earlier complaint lodged by the petitioner. Stop. Paragraph. There is, however, no report with regard to the steps taken by the police in response to the complaint lodged by the petitioner on 5th of July 2023. Stop. Paragraph. None represents the private respondents.
We have taken under that application, Lordship, we have taken a step under section 107 also, Lordship.
107.
Lordship.
Acha. The petition, the officer in charge, Batra Police Station, is directed to cause a fresh inspection, not inspection, inquiry, and file a report before this court on the adjourned date. List on 22nd of April. The parties are directed to maintain peace, and the officer in charge is directed to ensure that peace and tranquility prevails in the locale. Service is taken on record, report is taken on record. 22nd of April.
Lordship, one more humble submission. My petitioner also approached the SDO under Maintenance and Welfare Parents Act. So that is for this betterment, Lordship.
If she does not consider what is her betterment, what can be done?
Your Lordship, I'm appearing on behalf of the respondent number 6.
I'm for the petitioner, Your Lordship.
I'm for the state.
Yes.
Lordship, on 22nd of May 2023, my shop was suddenly gutted in a fire, Your Lordship, through short circuit. After that, my shop is insured under Cholamandalam Insurance Company. And over there, for that purpose, a report from the fire department is required so that I can claim from them. Accordingly, the fire department asked for the charges for dousing the flame. I have taken all the steps. I've paid the amount required for dousing of the flame.
Let me see your report.
Yes, Lord, but it's not very.
Is there anything mentioned from the fire
I'll
department?
tell your Lordship. Let me tell your Lordship. They have not applied for the report.
Not applied?
And they have not paid 1,000 rupees. I'm handing you to it.
Yes.
There's a parawise instruction.
Yes.
But here it says that you have to file a report. You have to file it. File
Formal application.
and an application under the in a form. You have not done it.
Where is the form?
This is the form is
Statutory form. Is it there in the
yes,
statute?
I do not have it. But
Let me
it's
see.
your Lordship, can you see? Yeah. I'm sorry, it's not. Form
You check up what is there. The notification number is mentioned, right? You
Yes.
check up, you apply, they will provide you. Please come.
And they have to deposit 1,000 rupees because it's a commercial institute.
The petitioner seeks for a report from the divisional fire officer so that he may proceed with his claim before the insurance company. Stop. The divisional forest fire officer, Purva Mendipur division, has forwarded a report before this court signed on 31st of August 2023, wherein it is mentioned that as per notification number such dated at the
As
a
per-
sum of rupees 1,000 is required to be deposited from the deposited for obtaining the fire report. Stop. The petitioner has neither deposited the prescribed fee nor has made any application for obtaining the same. Stop. Paragraph. The instant writ petition is accordingly disposed of by granting leave to the petitioner to apply in the prescribed format for obtaining the fire report along with the prescribed fees. Stop. In the event such an application is made with the prescribed fees, comma, then steps shall be taken by the divisional fire officer to forward the fire report to the petitioner at the earliest. Disposed, report taken on record.
The report will be with your lordship?
Yes, yes.
Thank you, sir.
I'm appearing for the state. Yesterday, this matter got dismissed for default in my presence. And I was not intimated about the restoration.
It was not intimated.
No. My junior, after watching the list, suddenly found the item number, so I'm appearing. This writ petition is even not maintainable.
It was mentioned and it was specifically requested to
No
intimate. Acha, ashun to likhun. The writ petition was taken up for consideration yesterday, Kalke date 3rd. And as none was present on behalf of the petitioners, comma, the same stood dismissed for default. Stop. Thereafter, the same was mentioned by the learned advocate representing the petitioner for restoration. Stop. The court restored the matter and directed the learned advocate for the petitioner to intimate the same to the learned advocate representing the state respondents. Stop. Today, when the matter is taken up for consideration, comma, none appears on behalf of the petitioners. Stop. The learned counsel for the state respondents, even though, comma, there, even though not intimated, comma, is present in court. Stop. The conduct of the learned advocate representing the petitioners cannot be appreciated by the court. Stop. The writ petition stands dismissed for default.
Grateful to you.
Nobody is interested. Dismissed. Dismissed. Dismissed with the connecting applications.
Lordship, Advocate Salma Sultana Shah, who is appearing for the petitioner, is not well. So I'm.
Which one? This is
114.
114. No, the petitioner is here. Yours is item 115. Yes.
And the implementation of the order passed in the appellate or by the appellate authority in right to information at page 24.
Information. Where are your queries?
Where is this at? Page 11, madam.
Where is the query? Please tell me.
Page 11, my lord, at
Yes.
para 6 from the bottom.
Para 6.
From the bottom.
জানিতে ইচ্ছুক এত শতক জমির মধ্যে বেস্ট অন্তত পশ্চিমবঙ্গের পক্ষে কালেক্টর কোম্পানির দাগ জমির ক্ষতিপূরণ. You wanted to know whether award has been passed or not?
Order has been passed, my lord.
No,
Page
award.
29.
ক্ষতিপূরণ দিয়েছে. That means award,
Lordship,
compensation.
about whether the award has been passed or not.
Whether the award has been passed.
Or not. That is the question.
But this has been vested under the, not under the Acquisition Act, possibly the Estate
That is,
Act.
my lord, it is not taking of possession, but it is the case of the petitioner in different dags. But petitioner has been singled out. His forefathers, either of the petitioner or his predecessor in interest, land has been being shown, being recorded in someone else's land. But whenever it is taken that way.
1 minute. কোন কোন দাগ জমি রায়ত লঙ্কা ঘোষের অনুকূল রয়েছে? What do you have got to do with this Lankeshwar Ghosh?
Lankeshwar is a predecessor in interest of the petitioner.
All right. কোন কোন দাগ জমি কোন পাট্টা মঞ্জুর হয়েছে কিনা? Who is the SPIO? It's the BLLRO possibly.
BLLRO?
Not the DLLRO.
DLR, it is SPIO through DLLRO. BLLRO is
Reply is there at page 16. What is the reply?
Page 16, my lord, reply is completely different, my lord.
Why?
That's why, my lord, there was an appeal.
What is the plot number? Jail number 99. RS Khotian.
Plot number, my lord, come to my lord, in plot number 3666 Khotian number, the parta beneficiaries are these persons. So this information I already have. What I want to know, this information, the grievance of the petitioner is that these names are being recorded in there as parta holder, but the land has not been acquired. That is the core problem, my lord. That is the
land is not required to be acquired. Land is required to be vested.
Vested, without vesting, without taking up the possessions.
No.
These persons
They must have vested the land.
No, that has not been. They cannot substantiate. Consistently, they are unable to substantiate that to produce a record. That is the query of the petitioner. Lordship has harped on the. I am grateful that Lordship has harped on the right chord. That the petitioner is struggling to know the vesting case, how this case has been vested.
Where is your query? Your queries are not properly formulated.
জানিতে ইচ্ছুক হাড়োয়া থানার তো ব্লক মতে ভেস্ট অস্তের সরকারের পক্ষে কালেক্টর কম্পেনসেশন উপরে তো কবে জমির ক্ষতিপূরণ দিয়েছে?
You go to the compensation.
No,
this is the excess land vesting. Why will compensation be given?
কোন দাগ দেন বাই লর্ড সেকেন্ড কোয়েরি কোন দাগ রায়ত লঙ্কেশ্বর কোষের অনুকূলে রয়েছে?
Yes.
So they should have record because they are the custodian of the records. It is settled principle, my lord.
You give the plot number. Have you mentioned in your writ petition what are the queries, averments?
Yes, sir. Para 3.
Para 3.
Para 3. In the year 2021. The petitioner known that some land recorded in the name of different persons. Thereafter, your petitioner made an application on 10th August 2021 to the
None of your 1, 2, 3, none of your paragraphs make out the query properly.
The date of the collector of the compensation officer give compensation in respect of 11.11.
Where is the question of compensation coming?
Then, my lord, what is the dag number under Khotian number 248 in which retained land of Lankeshwar Ghosh? Let them answer this.
Please come.
Lordship.
The petitioner requires certain information. Do you have anything? State.
Lordship, this writ petition is not maintainable, Lordship. He has he aggrieved and dissatisfied with the order of the DLRO and filed this writ petition High Court. He has to file before the appellate authority.
Yes, I will see whether who is the appellate authority. You bring the information. Have you followed?
I have a report.
Yes, give. What does the report say?
Report says
the land was vested. Your BLRO should be given a good thrashing. The order that he is relying upon has been taken care of by the appellate authority and he has been directed to act accordingly, and even then he is relying upon the same order.
appeal case.
The petitioner claims to be the heir and legal representative of one Lankeshwar Ghosh, who was the owner of the land, measuring about 11.8 থেকে এতটা ঠিক আছে. The petitioner intends to know as to whether any portion of the subject land was vested to the state or not. Stop. In the event the same was vested, comma, the case number and the act under which the vesting was made. Case number, comma, date and the act on which the vesting was made. Stop. The portion of the land which was retained by the said Lankeshwar Ghosh. Anything else?
Nothing, my lord. On the second point, my lord, I shall satisfy your lordship on the next step.
What? What is the second query?
That is the first point, that in the excess land I can also entitled to compensation, my lord. That's why the query has been made for whether the compensation has been paid or not.
Whether any compensation was paid after the excess land. Excess, take everything. After the land stood vested to the state. The district land and land reforms officer, comma, not 24 Parganas, is directed to forward this information to the shall forward the aforesaid information to the learned advocate representing the state respondents, who shall thereafter forward the same to the learned advocate representing the petitioner. Stop. Relist the matter on 1st of April. এই ইনস্ট্রাকশনটা রেখে দেবেন, সার্ভিসটা রেখে দেবেন।
Deeply obliged.
Well, item number 113, I was appearing for the bank, your lordship. I don't know what has happened with the matter.
Nobody was there for the petitioner.
My lord, in item number 113, I'm being led by Mr. Devanik Banerjee. He's on his legs in court 6, my lord. That's why.
Who is he appearing for?
My lord, the petitioner. The petition.
And it has been dismissed.
My lord, kindly considers, my lord. Kindly considers he couldn't be here because he's on his legs in a different court.
Yes. Somebody else could have been here.
My lord,
Please wait. Let him come. 113 টা রাখবেন, ফাইল পাঠাবেন না।
115, I am bringing not today, the learned advocate on record is engaged in court room number 36, Lordship. Only make it not today.
Which item?
115. 115.
Your learned advocate by the side is saying that the learned advocate is sick, and you say that he is on legs.
Instructed me, Lordship.
What? She is unwell, you said?
His clerk instructed me, Lordship.
Then?
I got instruction from his clerk, from her clerk.
Then absolutely wrong information before the court. Where is the learned advocate? Bring her. I am passing it over. Call her. Yes.
My lord, I am saying for not today.
For whom?
I am led by Abhimanyu Banerjee.
No, who is he appearing for?
For the petitioner, my lord. I am for the petitioner.
2023 matter you are praying for not today. Why?
My lord, there is some difficulties.
What type of difficulty?
My lord, brief is not with me, along with me right now.
Who are you for?
No, I am appealing for the respondent number 1.
What is the matter?
Matter is, my lord, they are claiming that some rupees, my lord, 26 lakhs and odd, 26 lakhs 63,000 is due and payable by the Heavy Engineering Corporation Limited. Heavy Engineering Corporation Limited also issued a check to them. I don't know, my lord, whether check is genuine or not. Page 21. But they are asking for this payment.
For payment in the writ court.
They are saying, my lord, this check was issued by Heavy Engineering Corporation Limited. Thereafter, only a scanned copy of the check was forwarded to them, but check was not issued to them. This is their case. I don't know, my lord, whether this scanned copy of the check
And the heavy engineering is a party or not?
yes, party. Respondent number 2 and 3.
Acha, ashun to. An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. None represents the respondent numbers 2 and 3. Stop. Let a notice be served upon the non-appearing respondents. Stop. Released on 18th of March. Record the appearance of the union.
I am for the petitioner.
Yes.
My land encircled by a wall. The panchayat members come, demolish the wall, make a road there. There was already an injunction there. Injunction in violation of the injunction order. I file an RTI saying that kindly give me the memo in which the panchayat took a decision to demolish the wall and make a road there. The RTI is at page 57. And after that, since there was no reply, I filed an appeal before the district magistrate, which is at page 61. It was subsequently forwarded to the block development officer, which is at page 63. But I need
information.
Yes, madam. My prayer is reply to that.
Any instruction?
No, my lord, not yet.
Where is your query?
First query is at page 57.
57.
Kindly seize the app.
Page 67, your query is whether any panchayat member can do any such type of act without your order. What is the reply that you expect?
My lord, kindly seize page 61 once. That is the appeal. That
Appeal
one,
has been- that is routinely forwarded, my lord.
that one,
1 minute. If this is your query,
yes.
Is there any particular question to which you want a
No, my lord,
you
the query is not happily drafted.
happily drafted? There is no query at all. Forget drafting. Where is the query? Whether the panchayat member will do any act without the order. Whether any panchayat member can do this in this capacity. Are these queries? What do you want to know?
Lord, kindly seize page 61 once.
Yes.
Paragraph 2. I want the reference and the date of the memo of order of demolition as passed by the Gram Panchayat.
61.
61.
Yes.
That on 4th, 6th, men and agents of the Gram Panchayat demolished. I want the reference and the memo of the order of demolition as passed by the
Lord, your lordship is looking at page
61.
P12.
P12. With which my boundary wall was demolished by the panchayat officials. And after demolition, did anything take place? Road constructed or anything?
Road constructed, there is a plaque there saying that this has been constructed by the panchayat member. There was already subsisting order of injunction that has also been annexed.
Nature of question, your lordship kindly sees. Point number 1, 2, 3, 4.
The petitioner intends to obtain certain information under the Right to Information Act. Stop. Acha. The respondent number 3 is directed to forward the information with regard to the
What has
reference number
read petition that
and the date
SPIO
of the memo of the order of demolition passed by the Monohorpur Gram Panchayat.
But paragraph 19, your lordship kindly looks at.
With regard to the boundary wall of the petitioner.
Paragraph 19 kindly looks at. Page 9. He has been requested to appear before the Gram Panchayat on such and such date for collecting the information. Page paragraph 19, but no P11 is annexed. P11.
Good.
Take the P11. Annex currently.
What is this P11? What is this receipt?
My lord, most probably the petitioner was asked to appear on that day before the SPIO, but the annexure is wrong. The annexure
The
is wrong.
next 240 rupees can never be the.
No. My lord, that is a my lord, the tax receipt. That is a tax
Yes.
receipt. My lord, the annexure is wrong. But may I just show that there is no provision to make the applicant of a RTI to appear before the SPIO.
That is all right. But then you have annexed something. You've mentioned it.
Well, that is, my lord, the letter dated 2nd December 22 is not there, my lord, wrongly annexed.
কি বললাম? Where is the description of your property?
The description of the property is at page 57 at the bottom.
Petitioner, boundary wall of the petitioner, property description. Where is the address?
At page 57, my lord, at the bottom.
Page 4, paragraph 4 of the writ petition. Mauja Monohorpur jail number such and such. Page 4, paragraph 4.
Yes, my lord.
Property situated at.
Number 2, yes.
Situated at. Page 4, paragraph 4. Bracket দেওয়া আছে। ঠিক আছে? The information shall be forwarded through the block development officer, Barakpur 2, to the learned advocate for the state respondents, to be forwarded to the learned advocate representing the petitioner. Released on 25th of March.
That affidavit on.
Yes, service is taken on record. You get it done through the video. Central Board of Secondary Education. Is this a education matter?
My lord, this is, my lord, only correction of the, my lord, spelling of the name. My lord, what happened, my lord, the son of the petitioner, my lord.
Yes.
The senior secondary examination under the, my lord, CBSE board.
Huh.
And, my lord, subsequently he want to, my lord, his upper study from abroad. And accordingly, my lord, he deposited all his testimonial and found that, my lord, his birth certificate, his name Monish, M.A. NISA, and, my lord, all other testimonial M.A. NISA. Only, my lord, his educational papers, my lord, that is, my lord, M.O. And for that reason, my lord, he made, my lord, one after another application, as well as affidavit, as well as daily paper publication, and as well as representation. But, my lord, the CBSE, my lord, not at all, my lord, taken any steps to rectify.
Who appears for CBSE?
My lord, Mr. My lord, U.S. Menon.
Yes, Mr. Menon.
U.S. Menon.
Serve a notice upon him and come back. None represents the Central Board of Secondary Education. Stop. Let a notice be served upon Mr. Menon, learned advocate, who usually represents CBSE before the court. Stop. Released on 11th March. Where is your service?
My lord. Service, my lord, I have already, my lord, served, and, my lord, he appeared.
Affidavit of service not prepared.
My lord, I did not file in my file, my lord, I filed.
All right, leave it.
My lord, next one, my lord, the petitioner, my lord, next one. My lord, that is, I am also for the petitioner, my lord. Petitioner already received the information, he is not interested.
Very well. The relief sought for by the petitioner has been allowed by the respondents. Stop. In view of the above, the petition stands disposed of.
I beg to wait for the response number 3, Lord.
Yes.
Grateful motion.
I appear as Mr. Shuddhaswata Banerjee is appearing in this matter. I'm praying for just not today, my lord. And this is my affidavit of service, my lord.
Yes, you are for railway. Not today. 2023 matter. Ligun, accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List in the combined monthly list of April.
Good. Much obliged.
Yes. Record the unions present. Railway.
Oh, Didi.
120, Mr. Asim Ganguly for the state respondent. He left the court for illness of his wife, my lord.
Very well. Dismiss for default. One 21 stated appearance record হবে না কিন্তু 21. Learned counsel has left the court. Yes.
I'm for the petition. This is with regard to removal of unauthorized construction. The prayer has been representative has been made to the assistant engineer, but he is sitting tight over the issue. Nothing has been done. That is page number 16. That is response number 3. The assistant engineer, PWD.
Yes, state.
I'm for the private respondent.
What is your submission?
11.
What is your submission?
The private respondent are carrying their business since long more than.
Very well, Ashun. None represents the state.
The municipality is
Service.
trade license and enlisting the certificate.
Affidavit of service is taken on record.
Service.
The prayer made by the petitioner for removal of illegal encroachment over PWD land is pending consideration before the assistant engineer, public works department, Pontai. Respondent number 3. Stop. Learned advocate representing the private respondent submits that the private respondents are carrying on business from the said place for a considerable period of time. Paragraph.
And the municipality.
Do you have any authority for permitting
the
you?
municipality have enlisted the certificate and issued the license also, and electricity bills also they are.
No. Whether you have been permitted to continue business from the public land?
The municipal authorities are, and the for decide the land.
There is nothing on record to suggest that the private respondents were given permission / license to run business from the public land. Stop. Next. In view of the above, the respondent number 3 is directed to take steps for consideration of the representation filed by the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated. Our representation forward kore dite hobe. Disposed.
Madam, grateful, madam. Grateful.
Did you file your wakalatnama?
Let's do one thing. I have to submit. Let's if the
no, don't submit. Where is the wakalatnama?
Yes, I have ready, but make the ready the wakalatnama. But the respondent number 8 was wrongly recorded as Susmita Barik. It would be at Sukant Barik. Lords. If therefore I could not file, I have prepared the wakalatnama. I shall file. Let him correct the cost item.
He will not correct. Whatever is there. You file it in the department.
In the name of Susmita Barik, there is no trade was.
If nobody is there, nobody is there. The authority will not find.
Lordship, in the notice, in the
leave granted to file wakalatnama in the department in the courts by course of tomorrow. Yes, 123.
May it please the ladyship.
Yes.
Lady, I appear for the petitioners in this matter. I have served a copy of my petition on the respondents and
Ms. Devjani Rai is appearing for the enforcement directorate in this matter, Lordship. Lordship, she is on her legs before courtroom number 35. She requested me
What
to
is
pay
your
for-
prayer?
May I kindly indicate, my lord?
Yes, please.
So the petitioner number 1 is a sub-inspector at the Punjab Police, Patiala, and the petitioner number 2 being the wife of petitioner number 1. Both these petitioners made investments in securities markets and derivatives through an app which is called TP Global FX Support, my lord. Now, what happened is that this app used to facilitate the investments on behalf of the petitioners. The petitioners joined this app sometime in September 2022, deposited substantial sums. Now, the app, through time and again, used to reflect the returns on the investment that was made by the petitioners. Now, when the petitioners wanted to withdraw the sum of money, the account of the app showed that it was frozen, because of which no transaction could take place. Upon further inquiry, the petitioners found out that there is a PMLA action that has been going on against the companies that run this app, saying that they've entered into transactions which are illegal and wrongful using the money that has been garnered through these apps. So my relief today is that whatever investment I have made through these apps, since a part or portion of that is frozen and under the custody of the ED, I am today seeking for the investments that I have made, the refund of the investments that I have made.
If you go and squander your money in this manner, you want the writ court to come to your remedy?
My lady, I am a bona fide investor.
Not at
for
all.
price value.
Not at all. Will you not check the app where you are depositing the money? It's just like squandering money. Where from are you getting all this money? There are recognized banks, there are institutions, central government institutions, state institutions where you can deposit your money. You go and invest money in some private app, and now you come to the writ court and say, you grant me relief.
I bow down before your lady for what's falling down, but your ladyship will kindly
Let the
appreciate that
investment authority, let the enforcement directorate come. Where is she?
Lordship, she is stuck in courtroom number 35. Shall we?
I am
file
passing it over. Tell her to come. Please wait.
Yes, ma'am.
Oh, yes.
124, I appear for this state.
Where is Mr. Jana? He was here just now. What is it?
No, there is nothing, my lord.
Nothing in the petition.
Nothing in the petition. Petitioner, my lord, got the property by way of partition, and thereafter got the plan sanction in his name and started construction. One of his brother filed.
Yes, Mr. Jana.
144.
Your matter is going on.
Long
Huh?
back in the year 2020.
I'll hear him.
The inaction on the part of the police authority,
Hmm.
the aggrieved petitioner has filed this lead petition to the effect that by encroaching the land of the petitioner, the balcony has been overlapped to the land of the petitioner. In the respective objection has been made to the Pradhan.
Who has overlapped the balcony?
The private respondent, my lord.
So it's a private dispute. Why will the writ petition be maintainable?
By violating the Panchayat Act, that's why the
Violating Panchayat Act, go before the Panchayat bench. Why are you here? The petitioner claims relief under the provisions of the Panchayat Act, comma. Let the matter be released from the list of this bench for want of determination and be placed before the bench having determination.
Liberty to correct the
Liberty granted to correct the front
presentation form.
Presentation form and the front sheet. Yes.
In this matter, I am for the statement.
My mother's purchased 3 plots of land, my lord. My mother, the documents lying in the house had been looted in 1987. My father died, my mother died. Father died 2000, mother died 2017. I have no document regarding the properties which my mother had. I applied for certified copy before the respond number 3. That has been withheld.
That has been withheld. Certified copy not given.
My lord, kindly see the page 11, Annexure P1. What application they have made? They never made. They didn't mention the deed number, whatever. So how could we find it out? So whether there is no any deed has made or not? My lord, even page 12. Come to page 12, my lord. What they have stated that at the time of execution of said sale register deed, I was a child, but I think the said execution of sale registration deed took place between the year 1954 to 1964. And with the span of such period, the said sale or registration deed got lost somewhere, which I searched. Now what happened?
Let them consider at all.
What to consider? There is.
Why are you laughing?
Listen, don't. He is a very junior member. Please excuse. He is a very junior member. You are a senior. Do not look at whatever somebody is doing.
This is the application made.
I understand this is the application. Suppose
document. My client has no document.
You can get hold of documents from the registering office.
Registering authority, my lord, that document could not. They could not have.
If you go on for searching in respect of a plot number, you cannot get whether there is any document registered.
Your lordship, kindly see, I have mentioned plot numbers.
So you go for a searching report first. Thereafter, you take the number whether there is any document registered in connection with this property, and then you go for obtaining.
May I submit, my lord? Your lordship, kindly direct the respondent number 3 to consider the representation after hearing, my lord. So that I can
Till the court is satisfied that the representation can be considered, the court cannot pass order. Right? You take steps, you can get it. It is not very difficult to get it. Ashunto, the petitioner,
your lordship can indicate. Your lordship
the petitioner intends to obtain certified copies of certain documents from the office of the sub-registrar. Raniganj, Paschim Bardhaman. ঠিক আছে? Stop. The application made by the petitioner before the sub-registrar is annexed to the writ petition. Stop. The same appears to be very vague. Stop. Neither the sale/registration number, comma, deed number, comma, date has been mentioned in respect of the subject property. Stop. With such little or no information, comma, it will not be possible for the sub-registrar, it may not be possible for the sub-registrar to provide the certified copy of the documents sought for. Stop. Paragraph. it appears that the plot number in respect of which the petitioner seeks information is 1523 of Mouja Jamuria. Stop. It will be open for the petitioner to make searches in the office of the
3 plots are there, my lord. 2 plots numbers are, your lordship kindly see, that is, my lord, if your lordship kindly come to page 4, paragraph 4, my lord. Paragraph 4, my lord. 3 plots number have been given. 1523, 1523 and 1772.
1523 and 1772.
All are in Mouja.
Mouja.
Nandi Mouja. Jamuria Nandi.
1523
Jamuria
হচ্ছে
Nandi.
জামুরিয়া 1772 হচ্ছে নন্দী NANDI ঠিক আছে it will be open for the petitioner কি বললাম ওটা office of the sub registrar in the registry office. Stop there. After obtaining the specific deed number, application may be made before the authority for obtaining certified copy of the same. Writ petition disposed. Passover কি আছে? 113. 113 Passover matter? Yes.
Okay, I'm sorry, I was.
All right. Who is the other side? Yes.
Applications. But before I start, Lordship, I shall be very candid. The affidavit of service has been misplaced.
All right. If your learned friend is there, she represents everybody, then it is all right.
She is representing the bank. She is representing the bank. There were other respondents who are not appearing, Lordship, in the suit, even in the suit which has been filed at the instance of my learned friend. Lordship, they are not there. And also prior to me, Lordship, placing the writ petition, there are 2 applications which are pending. One is for condonation of delay and the second one is for substitution of the name of the plaintiff. He has expired, Lordship, and his legal heirs being, Lordship, his daughter and wife are to be brought on record.
All right. And how many days delay in filing the application?
84 days.
84 days. What is the explanation?
Lordship, paragraph 4 of can 2, can 1, Lordship.
84 days for performance of rituals and subsequent paperwork. This is not the ground for condonation. What is the relief that you are claiming?
My lord, the petitioner, the erstwhile petitioner, Lordship, is entitled to receive a certain sum of money from his father's will, which is deposited in the bank, which is being represented by learned friend.
How will a will be deposited in the bank?
He is to inherit a certain sum of money which is deposited with the bank subsequent to the probate that was granted in respect of the will.
All right.
So, Lordship, he applied, the bank thereafter filed a suit against all the legal heirs of the father of the deceased petitioner for declaration that for ascertaining who is the rightful owner
of the money.
Of the money.
All right.
Lordship, that suit was dismissed for default. The bank did not appear. So I had produced the will, Lordship, in the meantime. So, Lordship, what I was praying for, Lordship, also I shall add this, that they have since filed a miscellaneous case
for restoration.
It is pending, Lordship. The stage is SRAD. So, Lordship, when this was filed in 2023, Lordship, at that point of time, the suit was dismissed. So, the relief that I had prayed for is the bank to release the money in my favor. But on this date in 2025, Lordship, the situation is a little different because they have already taken out an application for restoration and the miscase.
Who are the other heirs to that money?
The brothers and sisters.
Brothers and sisters. The will was probated.
Will is probated, Lordship. That is annexed. Annexure P1, page 15.
And is the bank aware of the probate?
Yes,
they have sent.
they have sent by their representation, they have sent this to us, your lordship.
Yes.
My lord, there were certain, my lord, representations from respondent number 5 to 7 claiming that this money does not only belong to them. My lord, this is before the probate was granted.
Right.
So, my lord, the bank has moved a suit before the, my lord, learned civil judge. Now, my lord, that the restoration, my lord, the application is pending there. My lord, and in the meanwhile, my lord, probate has been granted. Now, the writ petitioner have passed away. So, my lord, if since the probate has been granted and the probate is not challenged anywhere by any of the party, your lordship, my lord, may a succession certificate to that effect be given to the bank? That the legal heirs, my lord, who are being substituted now because the petitioner is not
No
alive,
longer there.
my lord, may that be given?
What is the amount?
My lord, 9 lakhs and odd. Now it will increase a little bit. 9,10,000 something.
And does the will say that the money is to go directly to the petitioner?
Yes.
Not to anybody else, or is the petitioner only the custodian of the money to be handed over to all the other heirs? Nothing of that sort.
Kindly takes up page 18. The will has also been annexed.
Yes.
The bracketed portion, lordship, I understand my lord's brief is আমি আমার যাবতীয় আসবাব সামথিং নগদ অর্থ যা আমার স্বর্ণালঙ্কার আদি আমার মৃত্যুর পর আমার একমাত্র পুত্রর প্রাপ্ত হইবে। মানে this is the who was the original petitioner before your lordship. So,
The amount is not specified, isn't it?
amount, lordship, it is not specified, but we have taken instructions from the client and lordship.
This line is very vague.
Yes.
Because
যাবতীয় অর্থ, স্বর্ণালঙ্কার. It may be so many. The description is not there. The figure is not there.
my lord,
How will
figures perhaps, lordship, in wills, lordship, that is not there usually. Because they usually specify what properties are to be distributed
Yes.
amongst the legal heirs.
Yes.
And lordship, I might be wrong, but lordship, at page 18, lordship, this is the only line that I have also found with regard to the inheritance of the son, who was the petitioner.
But my lord,
And
once
How many bank accounts are there?
That I don't.
my lord, in the probate it is specified that
Is it?
my lord,
Is it specified?
my lord, we have at present, my lord, I do not have the copy of the probate, my lord, the
Yes.
order of the probate, but whenever an
No,
order
it is
passed, my
here.
lord,
The grant of probate, page 15 is here.
then I'm sorry.
Right, कोई पुनरुक्ति
Probate is
आ गया।
specified for us, is specified. Okay.
The will is there. The will appears to be very vague. How many bank accounts are there? There are other claimants also. But
It is not
then
even specified.
nobody is has challenged.
Come back with this instruction, lordship.
Please do.
May I come back on another?
আচ্ছা আসুন তো দেখি. The original petitioner has expired on 13th of October 2023. Stop. An application has been filed by the heir and legal representative of the original petitioner seeking substitution. Stop. There has been a delay in 84 days in filing the application for substitution. Stop. Paragraph. The a prayer has been made to condone the delay. Stop. The court has considered the application seeking substitution and the application explaining the delay in filing the said application. Stop. Being satisfied, both the applications stands allowed. Stop. The department is directed to carry out the necessary amendment in the cause title of the writ petition. Stop. The learned advocate representing the respective parties are directed to revert with updated instruction. Relist on 25th of March.
Very great.
Any other passover matter is there or not? Aro duto ache? Item 15. 115.
115. Time for the petitioner, Your Lordship. The service is not yet been completed, Your Lordship, to the GP.
I'm grateful.
Service is not complete. I am dismissing the writ petition.
Your Lordship.
Because it was filed in September.
Your Lordship.
And we are in
No.
March 25
Only
and
the
you
GP
say
has-
this service is not complete.
Your
That means
Lordship-
you are not inclined to proceed.
Your Lordship, there is no instruction from a client also, Your Lordship, and the GP copy has not been not yet been served. We served on 2023, and after that we going to the office of the government pleader, but we find that the copy has not yet been completed.
Copy has not been completed. What
Service
does
has not yet been completed, Your Lordship. We find it out.
that means you have not served?
No, yes, I served, Your Lordship, but I couldn't find the affidavit of service portion, Your Lordship.
Nobody is there. There is no recording in the office of the GP also that you have served.
I have served, Your Lordship. I couldn't find the affidavit of service, Your Lordship. I'm praying for just 1 day time, Your Lordship.
1 day time from 23, so many months went by, you did not find time, and now 1 day time.
Just I'm big.
Just now it was mentioned that you were unwell, you have not come to court. And now you are present before the court.
Your Lordship, not. I'm engaged in court number 36, Your Lordship.
When you pass on information to the court, please ensure that proper information is passed and the court is not misled.
Your Lordship.
Right?
Yeah.
Who are you appearing for? You in a different matter. Anjali Gunta, learned advocate for the petitioner submits that service of the writ petition is not complete. Step. The writ petition was filed in September 2023. Until date, the same has not been served. Step. The court is not sure as to whether the petitioner is genuinely interested, petitioner sabe, to proceed with the writ petition or not. Stop. As a sincere prayer has been made by the learned advocate representing the petitioners to adjourn the matter. Accordingly, the matter stands adjourned. Stop. List in the monthly list of April. Service in the meantime. Which is the next one?
May it please, Your Ladyship.
Yes. What is the instruction?
My lord, the instruction is, my lord, I am appearing for Enforcement Directorate. That is
yes.
Respondent number 225. I am appearing. My lord, already they have mentioned that the bank accounts has been frozen, but in a proceeding under PMLA. Now, my lord, as per the provisions of the Prevention of Money Laundering Act, my lord, lawful claimant has to go before the special court. Claiming the property. My lord, that is section 8(8). So we
give me the court where the matter is pending.
My lord, I will file a report then because it is as per their averment in the petition. My lord, I am reading.
You did not get any information.
My lord, that is the information because on basis of this, the officer in.
Ligunta.
So far as we've been able to ascertain, my lady, if I'm permitted to indicate, this pending before the special judge CBI City Sessions
Where is it?
Court
My lord,
at
is
Calcutta.
paragraph number 7 they have
Paragraph
stated,
7,
my
page
lord.
5, along with the
My lord, kindly allows us to file a report, my lord, in this regard.
money laundering /3/2023.
Actually, Gunta, the petitioner seeks refund of the money invested by them through the app. What is the name of the app you said?
TP Global FX Support Online.
Where is it mentioned? Achha, TP Global FX Support
Paragraph
Online,
my-
paragraph 2. And what is the quantum?
Approximately 26,55,000.
What do you do?
I am, my lady, a sub-inspector at the Punjab Police.
Where from are you getting so much of money to invest in all these private apps?
These are my savings, my lady, and my wife's savings. My wife is engaged in practicing medicine. So these are both of
Practicing
our.
medicine means, is she
She's
a doctor?
Yes.
She's a doctor. And all educated people falling trap over here. Acha. It appears from the averments made in the writ petition that the account, not the account, the application through which the money was invested has been frozen by the Enforcement Directorate, and a proceeding being money laundering /3/2023 within bracket paragraph 7 page 5. ঠিক আছে? Paragraph. Learned advocate representing the Enforcement Directorate seeks to revert with a report. Stop. Released on 1st of April. A report shall be filed by the ED on the adjourned date with an advance copy to the learned advocate representing the petitioner.
My affidavit of
My
service.
lord, sincere apologies, my lord, when the matter was called.
No, no, it's all right.
Engaged in court room number 35.